All right. Well, good morning, everyone. We're going to get started in just a second here. Waiting for everybody to log in. It's about 9 o'clock. We'll just give another minute for everybody to jump in before we get started. All right. Well, I'll get us started here, everyone. I'm Ed Ronsman with McCabe Ronsman, my partner, Mike McCabe. And we're going to get started in just a second, just a little bit, with everything with COVID and the pandemic and, getting through to 2021, everybody's probably pretty Zoom familiar after last year. But for those of you that haven't used it yet, or just maybe need to be reacclimated, we're using this as a webinar format. So the best way that we'd love to take questions from you, the best way to do that is when you click, there's an icon there that you can type in Q&A. If you can use that and type out your questions, that way we'll see it, and then we can make sure that we address them as best we can. And if we can't, we'll let you know, and we can always talk to you afterwards. So if you hit the Q&A button, you'll be able to then type that in. We'll be able to see it, and then we'll answer them as we go. The other thing is that we're also going to be recording this. So you'll see that. I'll have that pop up in a little bit. And actually, we are recording right now. I see that we're already recording. So we'll be able to make this available to any board members that maybe couldn't make it here today, or any managers that you work with. And we'll provide instructions for how to do that later. So before we get started, you can see on here that we have our attorneys from McCabe Ronsman. Again, I'm Ed Ronsman, Mike McCabe. Jim Roach, one of our partners. Jim, you can wave your hand here. Alex Amador, and Colby Keefe. We have Sam Friedman and Chase Mills. You all have probably worked with us. Maybe sometimes, you start working with us, or maybe you kind of see a name on the emails potentially, or even just on a phone call, but it's been harder for us to meet in person. So I wanted you all to see the attorneys that you've been working with. I think we just don't have James on here this morning. He's got a closing that he's handling. Otherwise, we'd have James Klempin in here as well, unless I'm missing him. Am I missing James? No. So we'll have our attorneys here, but Mike and I are going to be handling this. It is going to be about a 2 to 2.5 hour course for everyone. We have a lot of material. It's a DBPR approved course. So once you take this, what we'll be doing afterwards is we'll be emailing you your certificate, so that you want to keep that on file. You can put your name in the certificate. We'll have a list of the attendees from today, and we'll make sure to email everyone. And that way you make sure you keep it with your official records, and then you're going to be good from a state requirement for as long as you stay on the board. Now, if you drop off the board and then come back, maybe you take a year off for your mental health, for example. If you come back on the board, you would need to retake the class or sign the certificate. But we appreciate all of you attending today. And hopefully you get a lot out of this, instead of just signing off on a document stating that you've read everything, that you'll abide by it, that we can walk you through this and, hopefully provide you with some education today. So with that, I'm going to turn it over to Mike, who's going to be walking us through. I'm just going to minimize this here. Mike, there you go.
Good morning. I appreciate it, Ed. I think it's worth saying that this is actually a 3-hour course requirement. But because we've been doing it via Zoom, it's generally taking about 2 hours and 15 minutes, and then we can have some questions at the end that we'll answer on the Q&A. And I've already seen some people raise their hand on the raise your hand. So if you would just post the questions over to the Q&A rather than raising your hand, because we're not going to call on people to then speak. We're only going to do typed questions so that it just kind of speeds the process up. Nevertheless, let's get started. So if you didn't notice, Ed is wearing his Green Bay Packers tie. He asked me this morning, he said, should I wear this? I said, absolutely. Only because I wanted to pick on him a little bit. But we'll see what Tom Brady does this time. If anybody's a Packers or a Tom Brady fan, I'm curious to see how it all ends.
Even if you're a Buccaneers fan, we'll allow you to stay in. I won't boot anybody. I didn't make that a registration. And you can't see it, but I'm wearing actually Aaron Rodgers socks right now. So I'm all ready for the game on Sunday.
Does it have his face picture on it?
It does have his face
Oh,
picture. Yeah.
gosh, that's good stuff.
Yeah.
All right. Well, good morning. Let's go through this. I'm anticipating about 2 hours. I'll probably go on the operational matters for about an hour. For some reason, it's not going to next.
Here we go.
Okay. All right. So here's basically just the outline of the class that we're going to handle today. Topics, we're going to handle the operations. We're going to discuss matters associated with the elections, financial matters, reporting budgets and reserves. We're going to handle the official records. I promise everybody has heard somebody say government in the sunshine. Well, I will tell you, that's just from people running on a Google search. Government in the sunshine is an entirely different chapter in the Florida statutes. It's actually chapter 119, and it has zero application to the homeowners association realm. I like to kind of say that, but obviously there's things associated with government and the government in the sunshine records laws. There's some similarities, but it does not apply whatsoever to associations. As a matter of fact, I had a manager ask me that question just last week. And we'll kind of handle Ed will discuss the distinction between how it works and that process. Nevertheless, we're going to cover the objectives. We're going to basically increase your general knowledge and duty associated with the duties and obligations of the association, define the role of the board. There's things that people get on these boards for different reasons. And often it can be a certain thing, right? You want to fix parking violations or people not picking up dog poop and things like that. And I promise that's not really your main objective. Your main objective is basically assessing the risk of the association. I would tell you as a board member, you did a great job as long as you bind insurance and appropriate amounts of insurance for the association. And that kind of comes under the legal obligations as a board member. If there's one thing I can tell a board to kind of to be team members on, even though there's people on the board that you may or may not like or disagree with certain things, you can certainly agree that you need to manage the risk of the association. And then we're going to talk about association protection, things associated with the assessment protection, the insurance protection. And we're going to discuss just current association problems and issues. For some reason,
try to do it one more time. All right.
You want to give me the mouse?
Yeah. There you go.
It's lagging a bit.
Yeah.
By the way, it's pretty obscure doing a presentation with nobody in the room. So governing documents. Here, it's really important to explain to board members and people that are working in this business to understand exactly how these governing documents are different, and they do different things, and there are different mechanisms within the association. And actually here, they're listed in the hierarchy of authority. So first you have your declaration. You'll also hear that called covenants, codes, and restrictions, or just simply covenants. The declaration is a term that's most commonly associated with the condo association. Covenants, codes, and restrictions are terminologies that you'll hear in homeowners associations, but it's the exact same document. That's the document that is essentially a contract, or is a contract between you as the association and the homeowner. And the obligation of that is simply by the fact that they got a deed within that association. So if somebody says, I'm not, the declaration doesn't apply to me. Well, you got a deed that's within this association, which is encumbered by this declaration, covenant, code, and restriction. I do want to state, just backing up, this class does in fact cover both homeowner association matters and condo association matters. And there's areas 723, which is RV parks, that are in here as well. But so this class would apply to all of those areas. So your declaration is the instrument where you'll find things that encumber the land. you'll find how easements work. So say, for instance, you had a lake and there was access associated with a walkover. Not only in your plat, it'd be in your plat book, it would show the easement, but then in your declaration, it would say who has the obligation to maintain the easement, where it exists, how it works. So that's all within the declaration. Also, your architectural review committee is within the declaration. Those powers are created within the declaration. And just a lot of other powers are within that. Moving on, there's the Articles of Incorporation. So your Articles of Incorporation are the documents that are filed with the state that actually create your corporation. So you can go open bank accounts, conduct business, file taxes. Often you will never amend the Articles of Incorporation unless there's some obscure thing in the event that you're potentially borrowing money and the Articles of Incorporation don't allow you to borrow money. But I think the statutes allow you to borrow money regardless, but it's just one of those things that you need to look at when you're doing some of your larger type things for the association, especially special assessments and things like that.
Sometimes jumping in real quick, that sometimes the bylaws and the articles talk about the composition of the board and how many directors there are. And the articles may be specific on that as to how you change the number. And so while you might think it's a bylaw change, it's actually an articles change, which may require membership approval. That's one other thing too. Yeah.
Well, that's a great point. Let me tell you about the bylaws, and I'll tell you something that we see in a lot of instances. So the bylaws are effectively how you administer the corporation. Okay. So say, for instance, you're like, hey, let's discuss where are things associated with meeting issues. Those are going to be within the bylaws. So your declaration has basically encumbrances, things that happen on the parcel, and your bylaws tell you how to run your administration. So that's kind of simplified. Here's the funny thing about it all is lawyers are really good at they're professional plagiarizers. So the lawyers that wrote your bylaws and your Articles of Incorporation and your declaration plagiarized a lot of that information from prior developments. So what's kind of not so fun, Ed was talking about the bylaws and the articles working together with determining how many board of directors are on. Sometimes we see the bylaws say, they'll reference the Articles of Incorporation and say, the Articles of Incorporation indicate how many directors we're supposed to have. Then you go to the articles and the articles say, the bylaws are to indicate how many directors we have. So kind of a fun little slippery slope we deal with here and there. And then we can amend the bylaws or the articles to kind of clarify those types of things. And I'm going to tell you how to amend all these things in a minute. Moving on to the rules and regulations. So the rules and regulations define individual specific matters that are effectively natural extensions of the declaration. Meaning if the declaration indicated no parking on the streets, you could go back to the rules and regulations and you can't change the fact you can't park on the street, but you could say other things associated with defining what that is for no longer than 1 hour or something like that. Often we'll see rules and regulations, they'll manage, what's the best example? Parking, dog poop,
pet restrictions, right?
Pet restrictions.
Yeah, for condos, right?
Right. Maybe pool rules, common element rules, things like that. By the way, the reason I bring up parking, renters, renters, parking, and dog poop is honestly the 3 most common things that drive boards crazy. So you're not alone. So you should feel happy with that fact, in my opinion. But just talking about how to amend all these different instruments that regulate your community. So I'm just going to give you a typical scenario just so that you have some gauge of understanding. To amend the declaration requires a supermajority of the community. Typically it's 66 2/3. I've seen 66, I've seen 75%. And that is the entire membership to vote. So I want to tell you that because a lot of communities get into the fact that, hey, we want to do a declaration amendment associated with short-term rentals. And I'll be the first to tell you that unless you go and market that particular amendment, it will not pass. It is so difficult to get people to vote on something that, I mean, I love to raise hands, like how many people get quorum every year. It just simply doesn't happen. And that's 30% in homeowners association and 20% of the members in condo associations. It's very rare to even get quorum. So if you're not spending, and I say this, if you're not spending at least 3 months marketing a declaration amendment, I know this sounds crazy that you have to market a declaration amendment, but I promise it's simply what you have to do. You have to sell people on the idea that this is going to help the community. It's never going to pass, and you wasted, good money and good time fussing with it. And there's always people that are against you. So then it creates a divide in the community. So you really have to focus on it. I tend to set 2 town hall meetings. And we'll go, like the law firm will go to the town hall meetings, help answer questions. People are going to throw every scenario you could ever imagine at you. And naturally, you can't think of all those because this is your only association. So it's always helpful to have us there. But the declaration, again, supermajority of the membership. Articles of incorporation and the bylaws. Articles of incorporation are typically, and the bylaws are typically, it's not always, a board vote. Now, so just the board of directors. Now, part of that is that you have to send a super notice, right? There'll be a 14-day notice minimum required to amend these things if it's a board of directors vote. So the statute defaults to 14 days. Your documents actually may in fact require more. So I've seen bylaws say 15 days. So you have to look at both and figure out which one would prevail. So minimum's 14. If it indicates a higher amount, then that's the higher amount you need to stick to. So normally I make you raise your hands. Who knows where the notice requirements are listed in one of your documents? It's in the administrative documents, which are also the bylaws. Okay. So that's how you amend those. And then, but sometimes I've seen articles of incorporation and bylaws have to go to a membership vote as well. So that one's kind of 75% of them are board votes and about 25% are membership votes. Moving on to the rules and regulations. In every case but one, it is a board vote. I've seen it in one community where it was actually an association membership vote. The threshold was a lot less, but nevertheless, it was still a membership vote. So you got to pay attention. You would go over to the bylaws to make a determination of whether the rules and regulations are amended by a membership or by just simply the board. All right. I think I talked that slide through. Association must establish a budget, set aside future funds for future maintenance, collect assessments to pay common expenses, and believe it or not, even though you're on the board of directors, the rules do apply to you. So you have an obligation to enforce the rules against your own board members. Board responsibilities and what to know. So the protect and insure, I like to talk a little bit about this because the more common elements you have, the bigger exposure you have. So naturally, I always like to find out how many lawyers are in the room, but I can't see that. But nevertheless, you're from the outside world, you're a sophisticated party as an association. You're a corporation, you have shareholders, and because you're a commercial entity, that you actually have commercial insurance policies. And so what does that mean? That means that there are opportunities for law firms to make money off of your commercial policies, right? So that's why you see the personal injury attorneys, they want commercial trucking accidents because they have commercial insurance. So you have commercial insurance, and you can have massive claims against the association that you need to make sure you're protecting against and insuring against, and doing your best to not, naturally things are going to happen, right? But make sure you have adequate insurance. So you got to protect the interests of the association at large, avoid personal gains, act fairly and equally. So a lot of times what I tell boards is we can help with insurance advice, but we don't provide it unless specifically requested. It usually comes in the form of matters associated with losses. So say, for instance, you had a hurricane loss, and that's generally when we get involved on the insurance matters. But if you have amenities like a pool, and retention ponds, everybody has retention ponds. Naturally, you really have to really think about the risk associated with these. And, you hope no one ever gets in trouble in the pool or in a retention pond, but it happens. So having adequate insurance and maybe an additional umbrella associated with that is really good. One of the things I do talk a little bit about is that a lot of associations have this false sense of security, meaning our security gate. Well, the reality is often you have a security gate, right? And then there's access to walk right around it. Any person could ever do, right? Nobody has real security. So be careful telling owners about the security gate. We always call it access management. We call it access management because it's simply just vehicle access management. I ask people to raise their hands, like, who has a security gate? I'll see, 10 people in the audience, and I go, okay, who calls it security? They all say 10 people, right? And then I go, of those 10, how many of you have razor wire? Does it look like Fort Knox? And none of them say that, right? So now if you're telling the world you have security, the perception is you're providing security, but you're not. You're an association. And this sounds a little, I don't know the right word, but often people are offended by me saying this, but as an association, you're a corporation that owns real property, and you have an obligation to manage common elements. Your obligations are not to owners and their security. I can never protect Ed from his neighbor and whether his neighbor keys his car, right? I'm not providing that kind of security ever. So really, it's a difficult balance in protecting common elements versus protecting people. And your main objective is protecting common elements, and you want as little obligations as protecting people as possible, right? So, but you have to make sure, to the next part, you have to maintain everything appropriately, because otherwise you're not protecting those people and then they have claims. Nevertheless, make sure you're going to your insurance agent and saying, hey, are we adequately protected? Do you think we need an additional umbrella? Things like that. You need to be asking those questions. And as a board member, especially if you have somebody that understands insurances, certainly is very helpful to make sure you have all of that covered. Often I get a lot of questions associated with board members and specific insurance associated with being a director or an officer. Well, yes, your association actually has D&O insurance, directors and officers insurance, or make sure they do if they don't, that in the event that somebody makes a claim against you personally, that you in fact are covered. So it's funny, I had a board member one time, he says, look, he's an attorney from Kentucky. And he says, there's absolutely unequivocally no way I'm going to serve on this board until we get an umbrella policy. And I want you to send me all the statutes on the indemnity in 617, which is the statute associated with not-for-profit corporations. So I sent him the statute out of 617, and I referenced all the sections on how you're indemnified and all that. And it's actually done very well. And he's like, oh, wow, I feel extremely comfortable knowing all those indemnities are in place. And I promise, he in Kentucky, he sent me the indemnity paragraph in his not-for-profit statute, it was probably 25 words. And when I sent him ours, it was probably 25 pages. So I don't know if that's good, bad, or indifferent. I feel like you're more protected under ours, and he felt as such, but make sure you have that D&O policy to cover your personal, when people sue you personally, which happens. But the association covers all that, and they indemnify you from that. So the last piece is enhance the common elements, right? Promote rather than diminish all the common elements. Moving on. All right. This is kind of the what to knows on insurances. And so here's just some, these are more condo, right? 5 insurance clauses association should have or be aware of. So the ones on the left are generally associated with condo associations.
You could have if you have an HOA that has, you know, a clubhouse or amenities that they're insuring.
Right? Yeah, right. Like a big clubhouse, you would probably have a policy like this too in homeowner associations. So law and ordinance, if you don't have that rider with law and ordinance, say for instance, your building was built in 1985 and you go to rebuild it, they're going to give you replacement costs. But they won't give you to you with the additional obligations for law and ordinance, meaning the hurricane clips and things like that. So make sure you're thinking about those types of things. If that's a $20 addition on a policy, definitely worth getting. The wind-driven rain endorsement, make sure you're asking your agent what exactly that means. So this is a interesting endorsement that we've seen on policies of recent that basically say, well, if it's wind-driven rain, then it's not covered. Well, I think all rain that actually gets into the building is typically wind-driven generally, right? Because it's storm-related. So make sure you understand that endorsement. Generally, those endorsements change a little bit with verbiage. You may need to send it over to us. We can take a look at it as well. So that's always what came first, the wind or the rain. Always a difficult question to figure out, especially unless you're standing there and video recording it. The third one is proper coverage for all structures, including signs, light posts, dog houses. You'd be shocked how expensive some of these little things can be when they blow off your roof. And light posts are more expensive than you think. I've seen some that are $3-4 grand. Coinsurance penalty. I always get people to raise their hand. Like, coinsurance is the most confusing thing in health insurance, and it's not as confusing here, but I will tell you, basically a coinsurance penalty is basically this. Say you insured a building for $1 million, but it's actually worth $2 million. So you underinsured it. What they would do is if you had a claim and you had a $250,000 claim and they say, well, you underinsured it, so it's really worth $2 million. So we're actually going to reduce, since you insured it for $1 million, by 50%. So your $250,000 claim is now $125,000. So if you have a coinsurance penalty, be sure that you have the right amount of coverage. And honestly, you just need the right amount of coverage no matter what. Number 5, get replacement cost on everything. As to insurance claims associated with matters like wind-driven rain, leaks, hurricanes, floods, it's an absolute must that you bring those claims within 3 years. Moving on, townhomes, anybody for that matter can have construction defects. The association in a townhome and a condo can actually bring it as a class action and bring the construction defect claims against the developer. There's a statute of limitations associated with bringing the claim, and it's 4 years from when you knew or should have known of the claim. So that will start as if you knew of the claim prior to transitioning to the association, then that statute of limitation will start on the day it's turned over to you. So if you have concerns associated with construction defects, be sure to contact us. We can talk you through the time limitations. There's actually a statute of repose. It's the statute of ultimate repose. And basically what that does is it says, no matter what, whether you knew or didn't know of a claim, you can never bring a claim after 10 years. So they revised that about 15 years ago. It used to be 15 years, but now it's 10 years. So in the event that you have an association where you have water intrusion, and you think it's a roof leak, often it's actually just a wall leak. And pay attention to that. We have an expert that we can send out there. They'll go out there free of charge. They'll drive by the community, take pictures, and let you know just from a visual inspection on whether you have issues. And they're very, very good. These engineers, they can tell just based on how the structure is built, what materials on it, whether there's cracks, where the cracks are located. They can look at the windows. They can determine just from a visual inspection, they can see whether the windows were installed properly and whether the sealants associated with the windows are broken. They'll know exactly what that is. Nevertheless, what I'm getting at is be sure to let us know. We have engineering experts that we can send out there. They can be there within 5 days, maybe 2 weeks, and look at the property. So review of time limitation, you can certainly give us a call. We'll be able to give you an analysis with the statute of repose and anything like that. So moving on to board responsibilities. Yes, it is a board responsibility to act as one unit to set policy, right? So I like to give this example. I still am on my association board. By the way, they do it all wrong, but it's a small association. And they were doing a big special assessment, and that was going to cost, I think, $3,500 per house to put in a new pool that nobody swims in. Nevertheless, obviously you can tell what side I was on this. We already had a pool. I wasn't all about it. So I didn't vote to do the special assessment. But when the board decided by a majority that this is the path we're going down, I have an obligation to now fulfill my obligation as a board member on this association, which is a corporation, to proceed with not being a distraction, meaning I was there to write the check. So when the board makes a decision, it's time to move forward. You got to move past it. I get it. Everybody has a position on everything. And during that motion process, you absolutely have an opportunity to say what you want to say. Our story was on the pool issue. It was a developing story, right? It started taking place 2 years prior. And then ultimately when it went to the vote, after that, I was all for it. It's time to go. It's time to get in front of it, right? So I tell people that because naturally we're all coming in here with different ideas. But ultimately we have an obligation to the corporation. It's not an obligation to our household. Okay. So proceed as such. Enforce the governing documents. So you have an obligation to enforce the governing documents. We talked a little bit about that earlier. There are times there's a case, it's called chattel shipping, that is out there. You can look it up. But basically prior boards will sometimes not enforce governing documents. So what happens to a new board? Well, you certainly have an obligation to enforce those governing documents, and it may require a call to us and sending chattel shipping letters to owners to say, hey, you can no longer have XYZ, or you can't leave your garage, whatever it may be. We may have to enforce things that the prior boards haven't. So that's something that we can certainly help you as an association deal with. We can do that. Maintain the value of the property, right? Like keep the landscape up and the common elements. Conduct board and annual meetings. Naturally, those need to be noticed. And as we discussed earlier, the notice is found in the administrative documents, which are the bylaws. So just trying to hone it in. Set goals for the association. And I like to talk a little bit about the setting goals for associations, because the one thing I will tell you about an association is because this is where people live, they don't like conflict, right? So if you ran on an agenda saying, I'm going to fix everything Mike McCabe did, he was terrible, right? You got lucky you got on the board, right? I think the best way to run on a certain item is, hey, you talk about the future. So setting goals are about the future, right? So I say, look, I don't care what the prior board did, but this is what I want to do. And you say, you don't need to say you're the antithesis of Mike McCabe. You just say everything, don't say that scumbag never enforced parking violations. Instead, you say, moving forward, we are going to assure that all parking violations are going to be addressed appropriately. Things like that. Talk about the future. Don't talk about conflict. Ultimately, people will not be involved, and you will no longer be on the board if conflict is where you land talking about board stuff. So if you want to run for the board and continue to be on the board, which most people don't, but if you do, always talk about the future and talk about the goals that you've set and what you want to do different moving forward. You don't need to say anybody's name. You just say, hey, I want to do this. I want to maintain a better budget, and I want to make sure we have enough money is set aside to redo the roads in the next 5 years, things like that. So that's some good practical advice. Maintain the association's financial stability. So part of that is basically assuring that you have your association, your assessments current, right? So how do you, the only way you make money outside of some rentals and things like that is by collecting assessments. And I like to ask people, this part of it is, how many people believe the association can actually foreclose on someone's home? Well, yeah, the unit serves as security. And the reason that we can maintain association financial stability is the fact that our assessments can be collected through filing a lien and foreclosing on someone's house. It sounds pretty crazy, but that's how it works, because otherwise you're subsidizing your neighbor. So I think collections are covered a little more later. Mm-hmm. The board's legal responsibilities. This is one of my favorite questions to ask. Who's been told they are breaching their fiduciary obligation? Some people don't admit to it, but I promise 50% of the people in this in this presentation have heard you've breached your fiduciary obligation. Well, that's hopefully not true, but the key to this is that you, as long as you're exercising good business, ordinary reasonable care, and you must act with good faith, diligent care, and skill, and you're exercising good business judgment, you're not breaching your fiduciary duty. It's simply that easy, right? Now, say for instance, you decided to hire your son to put up a fence. It cost $1 million and he's never done a fence before, and you didn't look at his resume and you didn't disclose to the owners or the board that it happened to be your son. That's breaching your fiduciary duty, okay? But as long as you're acting in good faith, you're not breaching your fiduciary duty. Now, what I mean is, you go to the board meeting, you hear the presentations associated with the landscapers, you say, you balance what it is, what you're getting, the scope of work, the costs associated with it, the total contract, and you're saying, yeah, let's hire these folks. And then you proceed. You're not breaching your fiduciary duty. But I promise, for your duration, even if it's 1 year on the board, you will be accused of breaching your fiduciary duty. So
one thing, and Mike, if I could,
yeah,
what I like to, it's not like all the decisions that you made and that there's a report card or something and that you're going to be graded, and that if you get anything less than an A or a B, that you could be sued for a breach of fiduciary duty claim. As long as you are relying upon the professionals that you work with, and I like to say that you have, obviously you have your management company, they're licensed, and to do a certain job, that's what you've hired them for. If you've got a CPA that you need to rely upon, you rely upon your attorney. all the different professionals that you work with, as long as you're talking with them and getting recommendations for things that may be outside of your normal area of expertise or knowledge, that as long as you're relying upon that, you're going to be fine. And even if you don't have to go that far, as long as you've gone through the process of obtaining bids and interviewing companies or whatever it is, just because that company doesn't do a good job. The example I always like to give is if you hire a landscape company and then 6 months later, you realize these guys did not work out, they did not do what they said they were going to do, and you have to fire them. A member cannot sue you for breach of fiduciary duty if you went through the appropriate, interviewing and, they were obviously a reputable landscape company. That is not a cause of action for breach of fiduciary duty, as much as members like to say it when they don't like the decisions that you make. So as long as you go through that, and again, it says with good faith, diligence, care, and skill, you're going to be fine.
Right. One little snippet from a practical measure. Be sure you're looking at your contracts, i.e. with landscapers, when you're signing a 5-year contract and it's $5,000 a month, and people don't really say, well, what kind of obligation is this contract if we have to break it? So at $60,000 a year times 5 years, that's a $300,000 contract. So be thinking about and what's your termination, right? So if you said, hey, Mike, I want you to review this contract. First, I immediately go to the terminations and the indemnifications. Yeah. Those are the first two. If you said, I'm going to give you 30 seconds to review this, that's where I go. Price is obviously something you negotiate, and that. I don't know the price associated with what your landscape should cost. But I tell you, think about those contracts.
Elevator service contracts.
Elevator service contracts are terrible. Fire suppression contracts are also terrible. And so that's the sprinkler systems and associations. They make you there's indemnities that they're indemnified from their own negligence, meaning if they made it to where the sprinkler system didn't go off and people die in a fire, it's on you, right? So I think the reality is that I tell all the associations, when you're getting into these big contracts, it is so worth the money, because you are a sophisticated corporation, to have an attorney review those particular terms so that you can make sure that you're protected adequately. So be paying attention to your contracts and when you're kind of going through that process. Anyway, I'll leave it there. You have a duty of loyalty. So you have a duty of loyalty to the corporation. You have the duty of ordinary and reasonable care. Duty of confidentiality before, during, and after term of service. So say, for instance, we had a construction defect case going on, and we were talking about settlements, and the settlement's $5 million. Even though you get off the board, you can't talk about that. And sometimes you may not be able to talk about it based on the settlement agreement, and that people find out through looking at the budgets and things like that. So obviously, if you have specific questions associated with that confidentiality, talk to us. But that includes pillow talk, meaning don't tell your significant other things about the community. Every time I go to a board meeting, my wife constantly asks, so what's going on? Well, some things I talk about and some things I don't, right? So, and I've been chatting forever, it feels like, and I apologize about this, Ed. Build community, become community involved, seek positive resolution to community and member issues, emphasize reasonable living and respect amongst the owners. And this is going to sound crazy, but create healthy relationships with renters. I like to ask this question. Raise your hand if you have a renter next door, and people raise their hand. The next question is, how many of them don't know your renter next door? You don't even know their first name, and people raise their hand. And I go, well, what's interesting about that is you really do need to get to know these people, because say, for instance, their children are speeding down the road, and you have a 5-year-old and a 6-year-old and a 7-year-old. I'm talking about Ed, and an 8-year-old. He's got 4 kids. And you're like, hey, Bob, you can't even go, hey, Bob, because you don't know his name. So, but you want to be able to be in a position, hey, Bob, little Mikey drives 60 miles an hour down the road. And, the reality is, when he does that, if he hits some kid or my kid, he's going to ruin his life and everybody else's life. Or say, for instance, you want that renter to mow the yard. Hey, Bob, let me know if you need to borrow my mower. I got plenty of gas. and I promise by 5 o'clock that day, it will be mowed. So that's why it's good to actually know your renters, because people in communities like this, they honestly, it's a function of peer pressure, right? Like it's how what is the social norm? People are like, okay, yeah, I need to do that. And then they go out there and mow the grass.
And one thing too, Mike, with renters is if your association, there's a couple of things. One, it's good to know who's renting a home just for your neighbor standpoint, but from an association perspective, if for whatever reason that owner stops paying their rent or stops paying their dues, you can contact the renter, and we talk about that a little bit later. The other thing is you have that information on file. One thing too is just, I think that renters, if you provide them with like a welcome package saying, here's our covenants or here's our snapshot of our community, that they feel a little more invested than that like an owner would be if they're going to be there a long-term renter. So have some type of maybe a welcome package for new owners and renters to give them a copy of your rules and regulations and your covenants. And I think by getting them to buy in that they're part of the community, that you might have a better relationship with them from there's a perception that renters don't care about the community as much as the owners do and the residents do. And that by kind of bringing them in at the beginning, that you kind of build that relationship better too.
Should I take any questions yet?
Let's hold on. I think there's a lot of good questions. I think what we're going to do, because we have a lot of information, is we'll hold the questions to the end and see if we address some of them.
Got it.
Yeah.
All right. Establish committees. So as a board, if you go over to your bylaws, right, you can establish committees associated with certain things. You can establish an ad hoc committee just to handle specific items. You can do an ad hoc committee associated with a mill and resurface project of the roadways, or something, a special type project, or you can have your standing committees. So sometimes committees can be tough to deal with, because what ends up happening is you will put people on committees to potentially quiet. If somebody's mad about parking, you'll put Ed's coming in there every week and talking about parking. And then you put Ed on the committee, but he's the biggest barker. You may not want Ed to be on that committee because he's so biased. So think about who you're putting on the committee. You want people that can, you want people that can be problem solvers, not fault finders. So that's the key to this whole process. Board responsibilities. They're responsible to make decisions, set policy. They must reach a consensus on the policy and then a direction. And this is just understanding the board versus management. Management implements the board directives. They work with the president, and I highlight the president. It's hard to be the puppet to 5 individual people. So you really need to make sure you have one point of contact that goes to the management company that discusses procedures and what to take place. And you can't have the treasurer saying, go give a violation letter to Ed, but don't give it to such and such. So figure out who's going to be that person that's going to have that relationship with the management company. And then the management serves at the pleasure of the board. Communication with management, that's the key to the whole thing. You have to have a shared vision. You have to agree on expectations, maybe do a scope of work. If you basically say, hey, I want you to come out once a month, you say, what day is it, right? Or I want the meeting packet 5 days in advance of the meeting. You need to lay that out so that they understand. Understand the difference between setting policy and directing operations. Action lists and monthly reports are always very critical to associations. Mutual respect. You have to have respect for the management company. I understand you can get frustrated. They probably get frustrated with you as well, but you have to respect them. You are a corporation that can be sued for bad acts. So be sure to have mutual respect, corporation to corporation. Board member roles and responsibilities. You're elected by your peers. I'm trying to breeze through this a little bit. I didn't realize time was slipping on me. Responsible to conduct business and delivery of service of the association. You are in fact subject to the governing documents. Your trustees on behalf of others. You provide oversight and guidance to the association. So be sure to help out in areas that you actually have some profession. Say, for instance, you're a contractor. It'd be really nice to have you help out on things like landscape and things like that, and road milling and resurfacing. So Strong board members. I think I'll end here. Strong board members. This is not me. No, I'm kidding. This is me, but I've been this weak member. Okay. And I'll tell you, working behind the scenes, to try to not get that pool amendment passed. Nevertheless, extra, good character, strong integrity. And I'll tell you what, my favorite one is calm judgment. And I tell you that because when people are angry and they're yelling at you that you are a terrible person and this, and this, I promise some of the best responses you can ever give somebody are, look, thank you for your comments. We'll take it under advisement. You can never get engaged in a conversation. And I like quoting Mark Twain. He says, never argue with a fool in public because the onlookers don't know the difference. Meaning the onlookers don't know if you're the fool or he's the fool. And you're the person that has the most amount of information and people may think you're the fool. So do not get into an argument with members. It is never worth it. So calm judgment is a really awesome trait to have as a board member. Willingness to serve, committed to the best interest of the community as a whole, relevant experience or background, previous volunteer experience, strong people skills. I will probably be able to write a book about all the different HR and personalities we could write a really good book about all the different personalities we get to deal with in these boards.
Managers, especially our managers on here, would write very good books with all the board members that they've had to work with.
Well, they deal with more members too.
Right.
And being a servant leader, you're somebody that's like, hey, we don't have enough money in the landscape budget. We'll just plant these flowers. So weak board members, unable to put the welfare of the community first, works behind the board to run things his or her own way, impulsive, quick-tempered, has a personal or hidden agenda, puts individual interests first, little or no experience, unable to work with others. So there's three types of people that serve on boards. And you don't want to be any of these three. You want to be the servant leader, right? There's the power loss syndrome. It's the people that like, hey, I was really powerful. Now I am, and this feels good. There's the never had power syndrome. And those are the people that tend to just follow the now I'm powerful. And then there's the servant leader, right? So you don't want to be the power loss syndrome and you don't want to be the never had power syndrome. You simply want to be the servant leader. Like, yeah, I can, and the I can attitude. Feel like I'm talking to my 10-year-old. Do you want to take over? You want me to just
keep going?
Yeah. Okay. All right. So the president, if you've delegated, if you've hired a management company, you've delegated a lot of the duties associated with the other offices that are held by your directors. Okay. Just to give a distinction, every single person on the board is a director. Some of those directors have offices. So those two words have different meanings. So the president is a director who serves in the office of president, right? So they're the day-to-day officer. They handle the meetings. They call the meetings to order, announce the agenda, adheres to it, recognizes members entitled to the floor, states a question, calls a vote, announces the outcomes. They maintain order. They expedite business. Expediting business is really, really important. Getting people off the agenda back onto the agenda is one of your main obligations. And I like to talk about expediting business because a lot of communities have a hard time finding people that are willing to serve on the board. And the problem with that is two parts, right? It's the time commitment. And sometimes they feel like the board is doing useless things, right? They don't really understand. So if you want to get more involvement in your boards, one of the best ways to do it is expedite business when you have meetings. Try to make your meetings 1 hour long, period. 1 hour long. Always start on time. Okay. People can say, yeah, I go to the board, but I need to start cooking dinner at 8. But golly, they say the meeting's at 6, they start at 6:15, and then they chat about nothing for the first 30 minutes. And then they finally get to the agenda. And before you know it, it's 10 o'clock or whatever the time is. So as a president, I'm okay. Adjourn the meeting. You guys can talk, guys and girls can talk about whatever afterwards, but expedite business. Get in, get out, be done. Okay. You're familiar with all the rules and documents of the association. And typically, per the bylaws, the president appoints committee members, and they serve at the pleasure of the board. The roles and responsibilities of the vice president, they serve in the absence of the president. So if the president's not there, they serve in that role. The secretary is the recording officer. They are the custodian of the records. They keep accurate minutes of all meetings, and they sign the meeting minutes and other documents. So the secretary obligations, if you have a management company, are delegated to them, and it's proper that they are. Now, as the secretary, you'll sign the minutes, but that's it. And the management company will be the custodian of the records, and they'll typically handle the meeting minutes. The treasurer keeps thorough and accurate financial records, produces regular reports of disbursements and income, produces annual financial reports to the members, submits financial records for audits, authorizes disbursement of funds. That also is typically delegated to the management company, appropriately, by the way. And you can work on the threshold requirements associated with when you want to sign checks or not sign checks. Is it $500 or is it $5,000? Like, that is something that every association and management company just has to have a meeting of the minds on how that process takes place. So pay attention to that. The roles of the manager, the scope of duties are specified in the contractual agreement. They carry out the policies as set forth by the board. They administer the services, programs, and operations of the association. They provide information, training, and leadership. So I'm assuming most of the folks on this meeting today, this board certification, probably got this notification from your management company. So i.e. they're providing information, training, and leadership. They act in the best interest of the association, and they keep boards informed on progress of key projects. Meetings, and I do want to just lay this out so you understand that there's different types of meetings, and understanding that they're different is the most important part. That's why I put this in here. There's an annual meeting. That's typically where the elections take place. They do a review of the year, especially associated with the budget, and they do a budget presentation. So that's when that's what happens at the annual meetings. Also, some associations will typically, if there's a big amendment they want to do, it may take place at the annual meeting. So, and I want to bring that up because the annual meeting is a member meeting, right? So you have to have a quorum of the members to have the annual meeting. Now, board meetings are different, and the frequency is determined. Whether you have a board meeting, that is defined in the bylaws, right? We learned that. That's how to administer the corporation. You slide over the bylaws, you find out, are they quarterly or you just have them annually, set them as frequent as necessary. Then there's the member meetings, and then there's committee meetings. So understand that there's just different types of meetings, and all of them have a different meaning. So meeting requirements, quorum, it's required for official business of the association. So say, for instance, you're having a board meeting, you have to have a quorum of the board to do official board business. If you're having a member meeting, you're required to have a quorum, 20% for condo, 30% typically for HOA, can be reduced, but it can't exceed 30. It can be reduced if you would like to have quorum, but you have to have a quorum to have a member meeting if it's a member meeting, and that's the 30% or less. So any to the development of ideas constitute. Okay, so just so you know, if you're doing things and any interaction contributing to the development of an idea is constituted as a meeting. So say, for instance, you can't vote via email. So that's probably the best analysis to this, right? So I send out an email to all the board members, and I'm saying, let's hire Mike McCabe as our landscaper, and everybody votes yes. That's improper, okay? And you had to have a quorum of the members. Ed, chime in. Sorry.
Yeah, and I've taken the call on the second bullet point under quorum. I call that the barbecue rule. And what I mean by that is when COVID is done and everybody's able to have more social events within their communities, the question that you get, well, we have a 5-member board and we're at a community barbecue and 3 of us are talking about association business. Are we allowed to do that? And that's where that interaction contributing to the development of ideas constitutes a meeting. So if you're talking about, hey, it's Saturday, we're having a meeting on Monday night, and 3 out of the 5 of us are at the same time talking about association business, that's technically a meeting. Now, what I would say is that's the legal answer. The practical effect of that is just try to limit your discussion. Nobody's saying that, 3 out of 5 or more board members aren't allowed to be around each other at any time. Just try to avoid talking through what's going to be discussed at your board meeting, because what the biggest thing to create distrust I find in communities is when members feel like the board is doing things behind scenes or outside of a meeting. And so, if you get to a meeting, you've got a big vote that's going to take place on a new contract, and somebody comes in and proposes it, and then there's a second and there's no discussion, all of a sudden you vote on it right away. If I'm a member, I'm going to say, well, how did you guys know you're going to go with that contract versus this one? Say, well, we kind of already discussed, or we were at the barbecue on Saturday. That's where people may have an issue with the way that the board's conducting. Maybe the vote was properly taken at the meeting, but you're going to find that that's when people get upset with the board, is feeling like they're doing things outside of it. So the same thing goes for, I've heard, like a workshop. If you try to have a workshop, like a budget workshop, and you have a quorum of the board present, even if you're not voting on the budget, for example, you still have to notice that as a meeting. So just be careful with that.
Yeah. There's anytime there's a quorum of people, even on a text string or an email, if you're discussing association business, that would fall within the catch-all of association official records. So you certainly have to be careful about what you're talking about. And I know it's so easy to send a text or an email, but as a corporation, they're not prepared to handle it that way. You really need to get to the board meeting and have substantive conversations about hiring Mike McCabe as the landscaper, and not saying, hey, this is predetermined, this is who's going to get the contract. Things like that. Be thinking about that, right? So as an owner, you would want to make sure that you had an opportunity to hear the dialogue and the analysis for why they're hiring one over the other, or how much it is. So we want relevant conversations taking place at the meeting. So just think a little bit about that. Proper notice is required. This is the Florida Government and Sunshine does not apply, but I will tell you there's a catch-all, right? I think there's 22 items that are official records, all the specific items like the declaration and the bylaw, all these documents, right? Financial records, you name it, everything's specified you could imagine. And then the very last one is a catch-all. Any and all documents or communications that discuss association business.
Right.
So that's the catch-all, meaning everything's an official record if it has anything to do with the association's business. So be careful about what you're doing. That is considered an official record. Quorum requirements, we've kind of talked a little bit about that. This is for condo only. Member meetings, a majority of the voting interest. Board meetings is simple majority of the board. Quorum is not required for an election if 20% of the eligible voters cast a ballot to have a valid election. Suspended voting rights don't count. So in the event that you have non-paying owners, you can suspend their voting rights and it would reduce the quorum amount. So we're finding that even in the good economy, which fortunately the collections aren't crazy right now, but even in good times, 5% delinquency, not 5% of the budget, I mean 5% of the owners, is typically where associations kind of sit. So just have that understanding. Quorum requirements for the HOA is 30% of the voting interest for the quorum, unless a lower amount is in the bylaws. But we have seen a higher amount in the bylaws, and then the statute controls. So the statute controls if it to 30%, and then you can have the bylaws have it be a lower percent, and then the statute doesn't control. So kind of a funky little thing. The quorum requirement consists of a majority of a lot of prepositions of directors prescribed in the governing documents. Decisions that require a vote of the members must be made by a majority at a meeting where a quorum is attained. Again, suspended voting rights do not count. You get those prepositions out of that thing. There's 3 in that one in 10 words. Board meeting attendance. All board meetings are open to owners. You can, in fact, have a board meeting that's effectively closed, and it can only be under 2 scenarios. 1, you have a litigation matter and your lawyer is present for the purposes of providing legal advice regarding the pending or possible litigation. However, the meeting notice is still required, but you just indicate a closed meeting. I do have associations, you know, I like just calling it a closed meeting. I do have associations that like to call it executive sessions. I think it creates a little bit of unhappiness among members because they feel like they can't be involved in your big time. So I like to just call it a board meeting that's closed. So, but whatever you call it, it's okay. But just think a little bit about how it would make you feel if everybody said it, you know, executive session. Maybe it doesn't make you feel anyway, but to me it does. Personnel matters. So say, for instance, you're a condo association or a homeowner association, and you actually have an employee, then you can talk about personnel matters, HR matters associated with that employee at a closed meeting, but lawyers are not required to be present.
And I would say that this hasn't been tested as much in terms of what constitutes a personnel matter. Probably the most frequent one that I think is in a gray area is if an association's looking to hire new management and they want to interview them and consider it to be a personnel matter. I've kind of, and you could probably ask 10 attorneys and get 10 different answers on this. I typically, kind of what Mike said, which is it more current employees, especially if you have an employee, I think that you can maybe extend it to if you have some type of a specific performance issue with like your manager, even if they're not an employee, but an independent contractor, like most of them are, you know, where they're not your employee, that you have like a disciplinary or personnel issue. But I wouldn't extend that to close off from the membership the ability, you know, if you're thinking about hiring somebody else and you're interviewing them, if you have a quorum of the board, that should be probably done in an open board meeting, is what I would say.
I would agree.
Yeah.
Board meetings for condo. These meetings can be taking place via video conferencing. This was revised in the statute.
It's actually for HOAs too. Yeah.
And HOAs too. We changed that a little bit. So you can participate in the meeting via telephone or video conferencing, which is happening more and more so now than ever. Email. All right. We already said this, but there's an absolute prohibition of voting on matters via email. Okay. There was different things in place while we had the emergency powers when the COVID matters initially took off. There were things you could get away with associated with voting via email, but we do need to have board meetings. It can even be telephonic to actually cast votes on association matters. So an absolute prohibition on this, HOA and condo. Planning a board meeting, define the purpose, create an agenda, date, time, location, review the minutes, treasurer report, any other committee reports, put your action items, new business to be considered, and invite the appropriate vendors to discuss different matters associated with the contracts you're reviewing. These are my meeting hints. Start on time. If you want people to serve on your board, start on time. It's really good to be succinct about what you're doing. Stick to the agenda, exercise Robert's Rules of Order and the parliamentary procedures. The key components associated with that are the motion. You get someone makes a motion, you get a second, you call it to, you have a dialogue, a debate, and then you call it to a vote. So meeting hints. All right. They're important documents maintained by the association. They serve as an official record for the association. They serve as a basis of the action taken by the board. I have another slide. Okay. Yeah. So here's the slide of the contents about meeting minutes. A lot of people want to put a lot in meeting minutes. I will tell you less is more. Get in, get out, be done with it. just indicate the kind of meeting, date, time, place, who chaired the meeting, results of quorum, any action or inaction. It's a record of what was done, not what was said. So for instance, and make sure you record the votes in the summary reports. So I always like to talk about the general comments when you get down to the bottom and people are bringing up who knows what. If you write verbatim, even though you have a recording of what Ed said associated with parking, and Ed said, it drives me crazy when such and such parks in the road, he parks the wrong direction, he doesn't park on the curb, like, and this long thing where Ed spoke for 3 minutes and you try to write that word for word, I promise Ed will call you and tell you that's not what he said. And you're taking it out of context or anything you could imagine. My recommendation would be simply put, Ed Ronsman made comments associated with the parking. Now, you may add a little more, but I would keep it very generic and very vanilla, okay? And then you could go insofar as to say, we'll add an agenda item associated with the parking. And then people could come in and, you could get a little more defined. But be careful trying to write things verbatim. It never works. Unit owners have the ability to participate. They may speak on any designated agenda item. You can adopt rules associated with how those members can speak. So the way Robert's rules work is that somebody's identified by the president, the chair of the board, identifies somebody to speak. You set a timer for 3 minutes, put a loud ring on it and say, that's it. And we need other people to have an opportunity to speak. And also we need to expedite business. So here's 3 minutes, say what you need to say. I will tell you, do not get into massive dialogue with owners about things that are going to happen. Sometimes a good response is simply, thank you for your comments. Other times obviously require a different response, but if somebody is just heated and you can't calm them down, unfortunately, you kind of just need to do that. So you can set up how they speak up front in the meeting. Members are entitled to be heard regarding matters that the board intends to consider. That's an absolute. Emergency actions may be added to the agenda. Meetings can in fact be recorded. So you can adopt reasonable rules associated with the recording. If people are doing it to try to be a pain, we can pass rules that say it has to be this and it has to be announced and things like that. But meetings can in fact be recorded. You can't stop that. You can set time limits, frequency, and limit board responses. So calm judgment, limit board responses, and I promise you'll do better. Finding and suspension. You want me to cover this?
I can handle whatever you want to do. Yeah.
How do I back up? Oh boy. Oh boy.
Go to previous right there. Yeah.
Okay. Is this?
These are the, before
right.
we go into
So
elections.
why don't we flip seats so you can be in the hot seat?
Here, I'll take it right here.
No, be in the hot seat.
In the hot seat?
Yeah,
All right. Okay.
Come on,
All
man.
right.
See you front and center.
Okay.
I think, right?
Sure. All right. So, and one thing that I wanted to mention too, regarding the meeting minutes, and Mike touched on it, and we touched on it before with the, that meetings can be recorded. The reason why you don't want to have the meeting minutes be a transcript is, like Mike gave the example of parking, and somebody said, hey, I don't like the fact that my neighbor keeps parking here, or they're parked the wrong way. What happens if there's an accident later, for example, and then somebody goes through the minutes and they can say, well, the board was made aware of this and they didn't take any action on it, right? They could point back to the minutes for something that might seem innocuous or may not, and I'm not saying that the association would be liable in that context so much as it's something for somebody else to use against the association. Another one that's common would be that we've seen, and from like a construction standpoint, is, hey, I noticed we've had some cracks in our stucco. Should we do anything about it? No, we'll cover it, in our next repainting 2 years from now. And then all of a sudden there's further damage. The association files a lawsuit. The defense is going to say, hey, it looks like you had some issues with your stucco way back when, and you guys didn't do anything about it. So by going into that type of detail in the transcript, in the meeting, and make it look like a transcript, is that there would be things that could be used against the association later. You might have board members that even say, I demand that it be reflected that I brought this up and this and this and this. That's why you're able to record the meetings. If an owner feels like they want to have a transcript or a recording of what was actually said, they have the ability to do that. It doesn't mean that you have to include it in the minutes. So that was just one of the things to mention there. So finding and suspension of use rights, I wanted to add this in. Previously, if you've taken this course, I kind of had it way at the end, but I know that a lot of you have questions on this. So I kind of wanted to run through from an operations standpoint how it happens. The board imposes the fine. The statute used to read that there was a committee and there was a recommendation made to the board, and then the board would impose the fine, and that's when it's final. Now the statute says that the board imposes the fine, but that it can't be collected from the owner until it's approved by the committee that's made up of non-board members, non-officers, and they can't be any spouses of, family members of those. And that you have to have 14 days notice. I did get a question recently. It's a good question. It's something that comes up and says, well, it says you have to give them an opportunity for a hearing in front of that committee. Does that mean that if they don't request it, that the fine is going to be automatically imposed? I've given the answer that you should still schedule the meeting regardless of if they request it. There are some arbitration decisions that apply to condos, but the statutes are similar between the condos and the HOAs. Then judges typically find those arbitration decisions to be persuasive, if nothing else, where they state that you have to provide due process and that they never had the hearing. And so I would recommend automatically scheduling that hearing, even if the owner never requests it. And then the committee can show up. They can say, here's our package from the board. They impose the fine on this date. Here's a copy of the notice. They gave at least 14 days notice. Nobody's here tonight. Do we as a committee approve the fine that's been imposed? And then they can reflect it. Usually I recommend having some type of a checklist and then a written record of what was done at the committee meeting, which that can include the fact that the owner didn't show up. So that's one thing that I'm asked about a lot. And I would just recommend having that scheduled, even if they never say that they're going to attend. Once the fine is imposed, it's due within 5 days of the hearing. That's also why I think, that was amended a couple of years ago to state that the fine is due within 5 days of the hearing. And I think that implies that you have to have the hearing still. You can't just, say that they have to request it. So that's the other thing to take in consideration. And then from practical consideration, and one thing that's been brought up a lot, and it hasn't been tested yet, some boards maybe only meet quarterly, but they say, well, we don't want to wait until our next quarterly board meeting to impose the fine. Is there something else that we can do? And I've advised clients that there are some risk associated with it, but the board could make a motion to delegate its finding authority to either an officer or maybe the manager. And so then when there's a violation that comes time for a fine being imposed, in lieu of having a board meeting, you could have that person say, I'm imposing the fine as pursuant to the authority that's been delegated to me by the board, and then you set them for that hearing. There's a risk associated with that. An owner could say, no, it has to be done at a board meeting, and that's a non-delegable duty or power that the board may have. So that's the risk associated with maybe the convenience of having kind of a rolling finding process where you're not, tying it to a board meeting. The most conservative approach, of course, is to have it on the agenda for a board meeting. Maybe you have under new business, new violations subject to fine, and maybe you put the property addresses on there, and then you go through each one at the meeting where the board votes to impose the fine. Then it's reflected in the minutes, and then it goes out to the committee for a hearing. That's certainly the most conservative way to make sure that if that fine is challenged later, that we can show that we documented and went through the appropriate steps. The other thing I have on here is consider adopting a resolution. I've recommended this, and I've worked with a number of associations that we can help craft a resolution for your board as to how the finding process will go. The thing is, if you take a look at what the finding statute says for condos and for HOAs, and then, the cooperative statute's really similar too, is that the board imposes the fine, but it can't be collected until it's approved by the committee with at least 14 days opportunity for a hearing. There's nothing in there about how many courtesy notices have to be provided when the fine actually starts. It just says that it's due within 5 days of the committee hearing. And so I like a board resolution where it might say, hey, if you're in violation, you're going to receive a 10-day courtesy notice. You'll receive a second final warning. And then The third thing is going to be the fine's going to be imposed, and then you get in front of the committee to approve or reject the fine. The other thing is just when the fine is going to start. We've had a lot of discussion even in our office as to whether the fine should start on one of the earlier notices, or does it start from the date that the board or the delegate imposes the fine? Or do you put it in one of the earlier notices that says that, hey, you're still in violation. If it's not corrected, you're subject to a fine for each day that it's in violation. And then the board will approve that at a later date to then be put in front of the committee. By having it in your resolution, it's clear that you have an objective process that every member knows that they're going to be subject to. And it keeps you on task as a board to make sure that you're treating everybody the same way. So that's why I like having a fining process. I'll talk about collections in a little bit, and having a collection process, kind of a similar type thing, is also helpful for your community. I think the biggest thing for a board is just being consistent and making sure that you're not treating anybody differently. Maybe you're not intending to do that, but by having something that you can just look to and say, well, this is our process. Do we follow it for this owner? And having a guideline for it, it's going to help you out moving forward. And again, it's better to have the procedure in advance rather than reacting to a situation and making up the rules as you go, basically. So that's what we have from an operations standpoint. And like we said earlier, we have a lot of great questions queued up here. I'm going to wait till the end just so that we can get through this. So if people, just want to log off after we get through it, and then the people that want to stay on, we can help answer questions. So please feel free to keep typing the questions out. We'll get to as many as we can. So that way, when an issue comes up, that way you can at least get it into the queue there and we can try to get to it. So thank you all for your patience on that. All right, so elections for condos. Probably a lot of you are just went through your elections if you're new board members, but just kind of as a refresher on the election process, the regular election must occur on the date of the annual meeting or as stated in the bylaws. This is for condos. I'll get to the HOAs in a little bit. The other thing though is that for all of you that aren't in a condo, that you're in an HOA, I still ask that you kind of pay attention to this part, because what I've been doing is we've really been recommending HOAs, if they have very loose election requirements, to amend to go to the condo form of election. And so that's what we're going to be talking about. So just consider that. Any vacancy on the board should be filled by electing a new board member, and the election must be conducted by secret ballot. You cannot vote in a condo election. You cannot use a proxy. It has to be done by secret ballot, filled out by the owner, either dropped off at the date of the meeting or that's mailed in advance. And there's a process for it. Provisions may be made in the bylaws for a board member term limits. If the term limits are not defined, then the term expires upon the election of their successor. So what that means is that by default, you have a one-year term unless you have anything else as stated in your documents. And the Condo Act was changed a couple of years ago. It used to be that you could only have a one-year term. Then it said that you could have a 2-year staggered term if that's provided in your bylaws. Now it says that while the default is still a one-year term, your bylaws may provide for other terms. So now you could go to a 3-year term, for example, as a condo, or a 2-year non-staggered, or whatever it is. It just needs to be provided for in your bylaws. And then a candidate must be eligible to serve on the board at the time of the deadline for submitting the notice of intent to run, which is 40 days before the election. So, and we'll talk about this on the next slide, but the first notice goes out at least 60 days in advance. It's a call for candidates. You have to get your name in no sooner than 40 days prior to the election. So if you get your name in on the 39th day, there's a ton of arbitration cases that say even if it's faxed and the fax goes through at 12:05 a.m. on the 39th day, they find that to be untimely. And so it is a nice, when I say nice, it's kind of a hard and fast rule that I know managers and board members, it kind of provides you with certainty that there's no, really judgment to make on your part. It's so objective that you have to follow it. And so it's kind of a way to say, hey, even if I wanted to, I can't, because this is what the statute and the administrative code provides. I just talked about this in terms of the term limits. You can have longer than even a 2-year term now, as long as provided in the bylaws. The other thing is that for condos, you may not serve more than 8 consecutive years on the board unless the candidate obtains 2/3 of the votes cast at the election, or if there aren't more candidates than vacancies. There's some questions still as to whether or not that's retroactive before the statute changed in 2018. So if you do have that question, you should speak with your legal counsel. If you're working with us, we're happy to look at that and advise you on that. But if you have 5 members running for 5 seats and one of those has been on the board for 8 years or more, they're still allowed to run and you don't have to worry about it. They could still run even if you have an election. They just need to obtain 2/3 of the votes cast. If they don't, it would be the next highest vote getter that would be elected. So we talked about the first notice. It goes out 60 days in advance. We talked about that you have to get your name in 40 days. This is one of the little confusing things. And I was actually on a panel yesterday. If any of you were on that, there was a specific question that said, well, what if their intent to run is really their candidate information sheet? And it's, it's a kind of a little bio or resume that's submitted. And the conclusion was, as long as they get it in on the appropriate time period, which is 40 days in advance, that you should treat that as the intent to run. But what I did say was, if that's the only thing they submitted, which is the information sheet, and it was done with the 35 days prior, that cannot be used as their intent to run for the board. So you have to say, I'm running for the board 40 days in advance. Then you have another 5 days after that, if you didn't already provide it, to get your information sheet in. Why they have that 5-day difference, I'm not sure. Maybe it's to see if they even needed to provide one. If you have 3 people running for 3 spots, then you might not feel the need to even submit one. I don't know. Most people do it at the same time. And so I would think that you'd have it done at the same time for the statute, but maybe they'll correct that at some point. So then after that the 40-day and the 35-day period runs, you then submit the second notice, which then would have the agenda, and it's provided no less than 14 days and no more than 34 days prior to make sure that you have, the appropriate cutoff period for people to get their information sheets in. Has the agenda, and then it has the ballot listing all of the eligible candidates, and it's on there and it's alphabetical. There's no favoritism or anything like that. And then any candidate information sheets. One thing that I'm asked is, what if somebody puts on their information sheet something that's incorrect, or, that might be kind of, subjective comments regarding the past board and why they're running and what the board did wrong. You can't keep out an information sheet if you disagree with what they include on it. But what some communities will do is the president might submit a president's report or something that might say, hey, you may have received information like this. Here's coming from me directly. But there's nothing in the statute that allows you the ability to keep something out that you might disagree with as a candidate information sheet. All right, so that's a process for condos. For HOAs, it's a little bit more of the wild, wild west. They're bringing it more into kind of closer to the condo side, but there's still a lot of key differences, and I'll go over that. But the regular election must be held on the day of the annual meeting or as stated in the bylaws, must be conducted in accordance with the governing documents. Directors must be elected by a plurality of the votes. Any person, and this also applies for condos, any person delinquent more than 90 days or has been convicted of a felony and has not had their civil rights restored for at least 5 years is not eligible to serve on the board. So one question that we get a lot for condos and for HOAs is, we have a rule that says that you must be a resident here. You can't be a renter. An investor owner, that you actually have to be in the community and living here, using this as your residence to run for the board. We would state that that is not in compliance, that everybody is eligible to run for the board unless it's one of these 2 things, that they're delinquent in a monetary obligation or that they're a convicted felon and they haven't had their civil rights restored. That eligibility is determined at the time that their intent to run is for the condo side. And then for HOAs, if there is no cutoff period to get your name in, it will really be at the time of the annual meeting. So that's one thing to keep in mind too. A member may nominate himself or herself as a candidate at the meeting where the election's to be held, unless the governing documents provide a process for nominating in advance, which would be like the condo form, which is what I just talked about. So the biggest thing I would say, whenever our attorneys here are contacted about an election issue, I would say 95% of the time it's related to an HOA. And it's because the HOA bylaws are not very clear, or they're pretty loose. They might say, the election takes place at the annual meeting, you have to provide at least 14 days notice. That doesn't provide anything for a cutoff period, or, how the ballots are going to be sent out. Is it a secret ballot, or can you vote by proxy, for example? So really take a look at what your bylaws provide for your election process for the HOA. There is an arbitration case that says it was basically an HOA was running their election like a condo for, I think it was like 10 years. And they followed the same process. They let everybody know. And I believe that one of the homeowners, he tried to submit his intent to run maybe 30 days before the annual meeting. And the association said, no, you had to get it in 40 days in advance. You didn't get it in on time. Therefore, you're not included on the ballot. He challenged the election results, And the arbitrator ruled in favor of that owner because they said it doesn't matter what your process is, it's what your bylaws provide. And the bylaws were silent as to any type of nomination in advance process, which means that anybody can nominate themselves from the floor at the time of the annual meeting, and there really shouldn't be any advance ballot mailed out. And so even if you say, well, we've done this for so many years and we let everybody know and we're consistent with it, that still won't withstand a challenge likely if somebody were to challenge and bring it up to the division for an arbitration. So really take a look. If you just went through your election and you maybe felt like, well, I think we need to tighten things up a little bit, take a look at that. I know our firm has assisted a number of times. It's one of the more frequent amendments that I've drafted in terms of how the election process should go. This was updated in 18, again, kind of bringing it a little bit more in line with the condo side, which says that if an election is not required because there are fewer or equal candidates than vacancies, and nominations from the floor are not required because your bylaws provide for some nomination in advance process, then write-in nominations are not permitted, and the candidates commence service regardless of whether or not a quorum was attained. So this is a big thing too for HOAs, is that if you don't have that voting in advance, and you don't have like the condo side, which says that you don't need to have a quorum as long as you have 20% of the ballots cast. If you don't have that process and you have to actually make quorum at your annual meeting, that's a big problem for a lot of larger HOAs, especially where, it's really hard for you to make quorum, which means if you can't do that and you don't have a balloting process that's separate from quorum, you can never have an election, which means that your directors are going to be holdover directors. That means that they stay on until the next time that you can actually make quorum for an annual meeting. What happens a lot of times is that screws up your staggered terms, because now everybody is serving until the next annual meeting, even if maybe their staggered terms would have been up at different times. So that's why it's really important to look at what your bylaws provide and how you can maybe address that for future elections to avoid having the nominations from the floor, and just really tie it to an advanced balloting process where you get your name in by a certain time period. Recall, I'm not going to go through this too much. Just know that a recall it's the only way that you can remove a director before their term is up. This is another thing that comes up. I was actually emailed about this recently, where it says, hey, Ed, we have a provision in our bylaws that says if you miss 3 board meetings in a row that you're deemed to have vacated your seat on the board. My response is that, the statute controls, which means that the only way that you can be removed as a director is by recall, which is done by a member vote. It's by a member petition. Has to be done by a majority of the members. Once that's served on the board, you have 5 business days to hold a meeting and decide whether or not you're going to accept the recall effort. And there's very limited instances as to how you can reject it. So the big thing, I'm not going to go through too much into it, except to say that that's the process for removing a director on the HOA and the condo side. And then if you receive that petition, you got to have a board meeting within 5 business days to evaluate it. So it's a very quick turnaround. Usually you need to have legal counsel involved so that we can advise as to whether or not it's a valid recall petition or not. There's things we need to look at. So just take that seriously if you do receive that. All right, so some proxy rules for condos. Pretty much anything that requires a vote for a condo association, whether it's to waive or reduce the reserves, or reduce the financial reporting requirement, or to amend your documents, needs to be done by a limited proxy. Limited proxy is basically saying, I can't be here, so-and-so is going to be my proxy for the purposes of quorum. But for these specific items that you need my vote on, I need to vote yes or no on them. It's not enough to just say, I can't be there. Here's my proxy holder, and I trust them to vote however they want on it. Most everything for a condo that's more substantive, affecting your association, is done by a limited proxy. General proxy, it allows the proxy to use their best judgment in voting. That may be something like, the proxy holder may have general powers to vote to adjourn the meeting to a later date. It's very limited as to what, general powers they may have. Most things is by a limited proxy. Voting by proxy is not permitted for a board member election unless the association has 10 or fewer units and the association has adopted alternative election procedures. So for really small condos, you can vote by proxy, but you have to have that in your governing documents. And we talked about limited and general proxies may be used to establish a quorum. Proxies are valid for 90 days from the date of the meeting for which they're intended. So that's good if you're trying to have a vote and maybe you're not quite there. Maybe you need, majority of the membership and you've got 45% of them. And that's all that shows up to the meeting in person or by proxy. You can have a member make a motion to adjourn to a later date, maybe 30 days, to find out the other 55% that haven't appeared in person or by proxy. and ask them to submit that so that you add that to the proxies that were already submitted and those proxies remain valid. So it's a good way to try to, not have to start the process over again. For HOAs, proxy rules are a little more loose. It just depends on what your governing documents provide. Directors may not vote by proxy at board meetings. That's also the same rule for condos. If I can't be there as a board member, I can't provide a proxy, but that's why they have looser rules regarding, even if you can't be there in person, you can call in or video conference, whatever the case may be, and you're deemed to be present. Members have the right to vote by proxy. Again, it might be limited in your governing documents. You really need to check what your governing documents provide. Proxy is valid for the meeting for which it's intended, and then any adjournment for 90 days from that, just like for the condo side. But you may be able to use a general proxy depending on what your documents provide for declaration amendments, waiving or reducing reserves. It really is going to be determined what your documents provide. So again, big difference between condos and HOAs in terms of the proxy rules and how you're allowed to use those. So I know that some communities they don't like that a proxy holder, a general proxy holder was able to go around and say, hey, trust me, issue your proxy to me, I'll vote for you, without that owner having to actually cast how they want to vote on a certain issue. So they amended it to say that for these items, we're going to be like a condo and say that you have to vote yes or no, otherwise your vote's not going to be counted on that. So take a look at that. You can always amend your documents to require that. All right, so that's what we have on the election side. For moving into financials, we're going to talk about budgets, your operations, reserves, and the accounting method. You want to monitor your accounting records, must be open to inspection. Accuracy, of course, is critical. Establish your assessments, regular assessments, and then special assessments if you need them, and the process for that, and then what the financial reporting requirements are. So the budget, it allows your association to prepare for the upcoming year. The proposed budget includes all daily operational expenses and estimated revenues. For condos, the owners are entitled to 14 days written notice of the budget meeting and a copy of the proposed budget. It has to be mailed to them unless the bylaws or the governing documents require a longer notice. And then the meeting notice has to be accompanied by a copy of the proposed budget. For HOAs, it's not the same. You have to include on the agenda for an HOA budget meeting that assessments will be considered, but there's no requirement to provide a copy of the budget in advance of it. And it doesn't have the same 14 days notice requirement. A lot of HOAs just follow the condo rule anyways, because, maybe what they'll do is they'll provide a copy of the budget in advance of the meeting. That's the budget that's adopted. It's not amended. And then a notice afterwards will say that the proposed budget you received was adopted, and then you're going to receive a coupon book or something later on. But it is different between the condo and the HOAs there. So the annual budget, the governing documents set forth the responsibilities for preparing it and what it should include. Most budgets contain the administrative costs, your maintenance, taxes, insurance, reserves. And the big thing to remember is that your budget is an estimate. It's not a hard and fast. And this is what sometimes associations get caught up in. Maybe you have a budget for maintenance items, and let's say it's $15,000 for general property maintenance. But then your year goes on and you find that you have more issues come up than what you anticipated. And I've had some associations do this. They'll say, well, Ed, it's September. We've already run through that 15,000. So we're not going to undertake this maintenance project until the next year because we're over budget on it. Well, what I would tell you is just because you're over budget doesn't mean you shouldn't do the work. What I would be concerned about is if you don't undertake that maintenance and it causes, further problems that could have been mitigated, or, if it's a sidewalk fix and somebody trips over it later on and now the association gets sued, you'd rather spend a couple $100s or whatever it is to fix it and then adjust your budgeting in the future rather than saying, well, we got to wait until next year. So the budget is just meant to be an estimate. It's not a hard and fast that once you get to this, you have to stop until your next year. Obviously, you don't want to go so far over budget that you're going to be, running out of money or anything like that if you can avoid it, and wait till your next year. But just remember, it's an estimate. That's the biggest thing. So cash versus accrual accounting, you have your cash basis, which basically like, you're writing your checkbook essentially. Income is recorded when it's received. Expenses are recorded when they're paid. Most associations really operate on an accrual basis, which is that income is recorded when it's earned. It's a more accurate financial picture basically, and expenses are recorded when they're incurred. I put this up here for financial reporting requirements, just so you're aware, as each year goes on and why you have to go, depending on what your total annual revenues are. If your annual revenues are less than 150,000, it's a report of cash receipts and expenditures. If it's between 150,000 to no more than 300,000, it's a compiled statement. And this is where I'm always, if we're here live and I could see you and I could call on somebody, I always ask if there's a CPA here, because I would say, okay, you can explain this better than I can as to what goes into each one. But I can tell you that as you go up in these, you're going to pay a little bit more for your CPA. It's going to be more of a comprehensive report, basically, of what needs to be provided. 300,000 to 500,000, it's a reviewed statement. And then 500,000 is an audited statement. You know, I include this, but really I only mention it to say that there is a rule in the Condo Act. An owner is entitled to a copy of the financial report. You do have to provide that to them. If you don't provide it after they request it and after the division requires that it be provided, the division can basically penalize you by saying that you cannot waive your financial reporting requirements for the next 2 years, basically. So there is a penalty to it, because what a lot of associations do is say, hey, we're going to have a vote of the membership, which requires majority approval at a meeting where a quorum is met, that we're not going to have an audit done every year. We're going to maybe do it every other year. And so every other year you have this membership vote. Well, if you do that, but you don't provide a copy of the financial report, and the division has to get involved. And by the division, I mean the division of timeshares, mobile homes, and condominiums, that if they have to get involved with it, they can penalize you by saying, nope, you're going to have to do your audit for the next 2 years because you weren't forthcoming with your financial reporting. So again, just as a reminder as to what's required for your financial reporting requirements. So how do you fund the budget? Well, it's from the assessments required from each owner. The unit or the property serves as the security for payment. Mike kind of talked about this earlier as to, you know, some people not realizing that the association can foreclose on a claim of lien. The claim of lien is what the association records after a certain period of time and after notices are provided when assessments aren't paid. And that the property serves as security for payment. You can record the claim of lien in the public records and then foreclose on that lien, just like a bank forecloses on a mortgage. Other sources of revenue can come from rent, interest, or whatever else may be a source of income, but by and large, it's going to be your assessments are the income. And then the payment schedule must be determined. So really what you're doing when you're adopting your budget is you're going to figure out what are all of your expenses. And let's say you've got $1 million budget in terms of we've got $1 million worth of expenses between operating and reserves. So you take that $1 million as expense and say, all right, how are we going to get $1 million of income? You may have certain things that you can include that are a source of income. Maybe it's surplus from the previous year, but by and large, you're going to have whatever it is, $1 million of assessment income, and then divide that by your number of owners. And that's how you fund your budget. So you're never really starting by saying, we want to have a $200 a month assessment for each owner, and then we're going to figure out our expenses from there. It's really the opposite, where your expenses determine what your assessments are going to be. Something that comes up, sometimes you may have heard, well, hey, Ed, we're having a hard time because we're not allowed to raise our dues more than 15% than what they were in the previous year because there's a statute on it. The statute just says in the condo context that if you do raise them more than 15%, that the owners can petition for an alternative budget that can then be voted on by the membership. I've never seen that happen before. I know usually when I attend these and I ask managers, managers have typically stated they've never seen members propose an alternative budget and gone through this process. But from a statutory standpoint, that's all it is in the Condo Act. There's nothing in the HOA Act, but you do need to look at your documents. And this is where I think, Mike, you had talked about before too, about developers and attorneys that draft documents and they kind of borrow from other documents a lot of times. A lot of times developers like to put in, because if you think about it from a developer's perspective, and we may have some developers on here, I understand it from a business perspective, right? Is they may say, hey, the dues start out at this much, $50 a month, and they shall be raised no more than 15% each year. Well, why do you think they do that? They do that so that when they try to sell you the property from an initial sales standpoint, that they can provide you with a copy of the covenants and they can include there and say, hey, good news is that yes, you have to pay HOA fees, but they're not going to go up that much because we've limited in the governing documents. The problem is that they don't really know what should go into that assessment, and they really undervalue, because developers typically tend to have a lower assessment amount to try to, for marketing purposes, say, hey, come in our community, it's maintenance free and you only have to pay $50 a month for it. And in fact, they realize, well, no, we weren't funding for this, this, and this, and our dues should be $100 a month. But then the association's limited by the document. So really be mindful of that. That usually would then require a member vote to change it. So, but from a statutory standpoint, the only thing is in the condo context in that first bullet point. And then collection of assessments. This is where I like to say too that we have a 1 hour approved course for CEU credit for managers and for board members, of course, where we talk just about collections. I'm not going to spend that much time right now, but there's a lot of different things we can go into from a strategy standpoint. But for the main thing is that you need to know is that the manner for collection is stated in the bylaws or the governing documents, typically the declaration or the bylaws. For condos, it must be no less frequently than quarterly. That's the difference between the condo and the HOA. For HOAs, you can have an annual assessment or a twice annual assessment, but for condos, the assessments have to be at least quarterly. And then you can accelerate assessments for the delinquency. So you want to manage delinquencies, and how do you do that? And I talked about this before regarding the finding resolution or a finding policy, is having a collection policy. I could tell you that, and again, if I had the managers here, I could probably see you nodding your head right now. But a collection policy helps because you might have an instance where, okay, your assessments are due on the first of the month, but how do you know when to move forward from there before you really, think about recording a claim of lien or sending out delinquency notices? Having a collection policy is good because maybe you'll say, on the 20th day, a reminder notice will be provided and you have 10 days. If it's not paid within that time period, then the second notice goes out that imposes the late fee. It provides another 15 or 20 days for payment. And if it's not satisfied, or whatever the date is, that then it will be provided to the attorney for proceeding with a notice of intent to lien letter. So by having that in a policy that's adopted by the board, it really helps your management company because typically it's not your CAM that's usually dealing with this and making the decisions. A lot of times it's the accounts receivable person in the management company that is really taking a look at your accounts and running the financials and keeps track of member delinquencies. And so by having this policy, that person knows, okay, I can send out this notice without needing board approval, and then we can send it over to the attorney so the board's not having to meet every single time to determine if a next letter should go out. So having that collection policy is really helpful. You also would want to include, enforcement procedures, when the association would proceed with the lien foreclosure. And then this helps to apply your collection policies fairly and equitably to all your owners. When Mike and I were, really started to get involved with the association practice back in Mike, 2007, 2008, 2009. And where Mike and I, where we would see each other before we were working together, we'd see each other in court half the time during the week because of mortgage foreclosures or lien foreclosures because of all the delinquencies that were going on. And I could tell you for some communities, I would be contacted and say, hey, Ed, we unfortunately need you to send a letter to this owner. And I would get a financial ledger that when printed out, it's 2 pages long for missed assessments. And I would say, gosh, guys, it's this long before you sent it over. And say, well, it's one of our neighbors and they told us they're trying to work it out and they thought they could refinance or they're trying to short sell their unit and they haven't been able to work it out. So now we're sending it to you and they're 18 months delinquent or something. Well, by that time, the bank foreclosure is already pending and there's really not much that we can do from a strategy standpoint to get you paid as much as you can. By that time, you're just waiting for the bank to foreclose. So by having this process, you're really, even if you have a neighbor or somebody that is friends with the board member, you can say, look, we have this policy, we adopted it, we've got to treat everybody the same way. So have that. I really recommend that you look at that and talk with your, somebody from the accounting side, from your management company and your manager, and then with your legal counsel to really help craft that collection policy. We've done that a lot in our firm. We're happy to assist you with that. The other thing is just using the statutory remedies, any type of amenity restrictions that you may have. Once they become 90 days delinquent, you can suspend amenity use. For some communities that maybe have key fobs or barcodes or something like that, it's easier to do. For other communities, maybe from a larger gated HOA that has a guard and then an automatic gate, depending on if you have your barcode or your key fob. We've seen some communities that have gone through the voting process to suspend their amenity or their use access to turn off their automatic gate code so that they have to check with the guard every time. I can tell you that it gets old really fast for them, especially if you have multiple access points to your community and there's only one guard, but maybe multiple other access points for remote access, that now they have to go all the way around and go through the guard. We find that that's a way that members become current very quickly after they realize that could happen to them. So look at that. Also, suspension of voting rights. We talked about that a little bit before. That helps really if you're trying to have a vote done, you have all these delinquent owners that aren't really caring about participating in the association anyways, that by suspending their voting rights, you're removing them from the number of voting interests. and then makes it easier to pass and everything too. And then the other thing is application of rent. I'm going to talk about that. The big thing though, in terms of if you're suspending voting rights or amenity access, it's not enough to just have it in your documents that it's automatic when it happens. There are cases that say that if you become 90 days delinquent, that you still have to approve it at a board meeting once that delinquency reaches that mark. And you have to send written notice to that party of their suspension of their voting rights or their amenity rights. And for condos, it's actually that it has to reach a certain dollar amount, and there's kind of a waiting period before that suspension takes place from a voting standpoint. The main purpose of that from a condo perspective is that you don't have a board meeting the day before an election, and all of a sudden you've got 50 owners that you suspend their voting rights and you toss out their ballots the next day. You have to give them an opportunity to correct it. And so that's one thing that's different from the condo perspective than it is from the HOA side. I've also seen it not even having the board meeting where they go and it's 5 minutes before the annual meeting takes place, where they'll go through their AR, their delinquency report, and they'll say, all right, well, who's 90 days or more delinquent? Okay, this owner, pitch, right? They'll toss their ballots out. And I said, you can't do that. You have to vote on it and give them written notice. And now for condos, again, it's at least, I believe it's 30 or 60 days to provide that. So we can help advise you on that. All right, so for renters, real quick, I kind of chimed in way earlier about having relationship with renters and having a positive relationship. It helps when the owners, the landlords aren't paying their assessments and we have to go to the renters and say, hey, we're sorry to bother you, but you need to pay your rent to us until further notice. By having a good relationship with them and saying, hey, we really don't want to do this, and maybe if you want to talk to your landlord about making sure they become current, we won't have to bother you with it. Having that good relationship helps to make sure that that rent is paid, and we want to make sure that that happens so that you can get paid as to the outstanding amounts that are owed to the association. So whenever we're contacted as a law firm from the association or the management company, say, hey, Ed, can you please proceed with collections for this account? One of the things on our checklist is the property being rented? And if so, we'll send a demand letter right to the renter right away. And a lot of times that rent for that month can offset and basically pay off the delinquency at that time. And that's why it's helpful just to have a register of who's renting their home. And if you can get a copy of the lease so we know what the rent amount is, that you know what they should be paying you if we have to go to them for a delinquency standpoint. The other thing, just that there is some teeth, is that if the renter doesn't pay, you can actually evict them. I typically don't recommend that because all it does is that it kicks them out of the unit without actually getting money to the association. If you're going to kick out a renter, you might as well just go forward with the lien foreclosure and take title to the property so that you can control it and rent it out. This is one thing that came in. It's repair and rental of abandoned units. This came in a couple of years after really the mortgage foreclosure crisis that we had. But it allows the association to enter an abandoned unit, make necessary repairs, turn on utilities, and then charge it as an expense back to the owner's account and treat it like an unpaid assessment. You can also, without even having to take title, you can ask the court to appoint a receiver to then lease the property out, and the receiver, receives a payment or whatever. Usually it's like 10% or 20, and then the association can collect rent without ever having to actually take title to the property. So there are some processes in place for condos to do that. HOAs, because of the form of ownership between a condo and an HOA, I think that there was more of a incentive and a reason to give condos access and to take care of the property, because if somebody doesn't run their AC, for example, mold starts growing, that affects not only that condo, but neighboring condos and the common elements. Whereas if somebody's not running the AC in their home on a single family residence on their own lot, it doesn't really affect their neighbors aside from an aesthetic standpoint, but it doesn't affect them from a health and safety standpoint. So that's why there's different rules for condos versus HOAs on that. All right, so going into surplus funds, what do you do? It's a good problem to have. It includes all the excess monies retained by the association after deducting expenses. If you're a not-for-profit corporation and surplus is not from a special assessment, funds cannot be returned to owners. Typically what you're doing then is you're including that on your income for the next year to offset some assessments, or what you may do is you still report it as on the income side, but maybe you find a way to increase your reserves from what you normally would fund to offset that income so that your assessments remain kind of the same. Sometimes there might be a one-time unexpected surplus, but you want to keep your assessments the same. And if you just treat it as a credit towards future assessments, it may artificially dip your assessments for 1 year, and then you raise it the next year when there isn't a surplus. what some communities will do is say, hey, we had a $50,000 payment from, an owner that we never expected to receive money from. We don't expect that to happen in the future, and we're going to have our same expenses. So we're going to increase our reserve funding to offset that 50,000 so that then your assessments otherwise remain the same. So just look at that from a budgeting standpoint. Special assessment surplus: upon completion of the specific purpose, the excess funds can be returned to the owners or applied as a credit towards future assessments. That's what most associations do, is the latter, is to apply it as a future credit. And typically we look at that again by maybe raising the reserves and then reporting this surplus as an income side, and then it offsets just kind of like any other type of surplus there. So overview of reserve for condos. There is a difference between condos and HOAs because every condo, of course, you have a building that has a roof that needs to be replaced at some point and buildings that need to be repainted. And then you have a pavement that needs to be resurfaced at some point. So there are mandatory reserves. You have your roof, pavement, painting, and any other item for which the deferred maintenance expense or the replacement cost exceeds $10,000. So you have to reserve for all of those items. The budget must include a fully funded reserve schedule. So those are the mandatory reserves for condos. You can have a pooling method versus the straight line method. We do receive a lot of questions for this. Straight line means that you have all these, let's say you have 5 reserve components. You have your roof, your pavement, your painting, maybe you have your pool replacement, and maybe you have something else that's going to be, a deferred expense of more than $10,000. So you have those 5 components. You have to fund those each individually, and you can only pull money from those accounts for that purpose. That's under the straight line method. For pooling, you put all of those 5 reserve components, all of the money in essentially into one pot, and as long you can pull money out from that for one of the reserve items, so that maybe you wouldn't have normally had, let's say your roof replacement's $250,000 and you really only had $200,000 up to that point for what you thought you would need it for. As long as you have enough money from your pooled account, you can pull that money from it and it's for a valid reserve item. So it provides more flexibility. It doesn't mean that you can pull money out of a pooled account for something that's not a reserved expense. That still would require a member vote to pull that money for that item. But as long as it's a reserved item, the money all gets put into one pot essentially, and you have more flexibility for providing it. For HOAs, it's a little bit different on reserves. There's 3 ways essentially to have reserves for an HOA. If the developer establishes them, even if it's not in the governing documents, if you get a budget from the developer that has reserves established, you have to continue funding those. If the board establishes it pursuant to authority provided in the governing documents, or if the members vote to establish the reserves. So those are the 3 ways that you have reserves. Once you have them, you have to fund them pursuant to the appropriate formula, which is, and this is the same thing for condos, which is essentially stating what the replacement cost is, what the useful life, what the remaining useful life, and then how you're going to fund it so that you have that replacement cost value at the time that it needs to be replaced. You can waive your reserve funding by majority vote of the membership at a meeting where a quorum is met. There is some statutory language in there when you're going to be voting on it that says that waiving or reducing reserves may result in an unanticipated special assessment. The point is that if you should be funding X amount of dollars, so you have this money in 10 years from now, but if you're cutting that in half, by the time you get to that 10-year mark, you're not going to have the money available. And so you might have to specially assess the members. So as part of that process, there is a statutory requirement to advise the membership that, hey, if you do vote to lower this, you may be hit with a special assessment later. I haven't seen that as much recently. This was more of a factor when, again, the economy was worse and we had the housing crisis and people weren't paying their assessments. So in an effort to try to keep the dues lower and make them more affordable, boards were proposing reduced reserves just to at least try to cut the assessment amount down. But obviously that kind of, it comes later on, if you start doing that and if you don't catch up that funding later, you may have a special assessment at some point. So we talked about the funding method, straight line, where each component is individually reserved for. Pooling method is where the components are treated as a group funding so that you never allow the fund to drop below 0. Both are acceptable accounting practices under GAAP. The answer will be different under each method. So we've kind of talked about that. So again, Florida law provides that reserve funding should be included at a fully funded level. One question is, how do you know if our reserves are fully funded? The best way that you can do that is to have a reserve study done. And I talk about that on the next slide. but you have a reserve study done, and that's done by what's called a reserve analyst. These are professionals that you can hire. We can provide you with recommendations. Your management company can. What they do is they go out to your property. They look at all the items that you're reserving for. They take a look at what their useful life is. And then they take a look at what the standards are from a funding standpoint, what the cost, anticipated cost of materials, all that kind of stuff. And they'll provide you with what your recommended reserve schedule is to make sure that you have the money that you need when those items come up for maintenance or replacement. So if you get that report for fully funded reserves based upon the reserve study, the board has done its job, in my opinion, for providing for fully funded reserves. If you don't use that analyst, then if you could be subject to challenge later where a member says, hey, I don't like this, I don't agree, I think we should be funding more, and they could challenge if the board obtained appropriate membership approval to have for that funding level, the board's going to have to provide evidence as to what it relied upon for that reserve funding. So again, the best way to do it is to have a reserve study done. Talked about what the reserve schedule is going to include. It's going to all require deferred maintenance and capital expenditure items, the useful life, the remaining useful life, the costs, the fund balance at the beginning of every year, and then the required funding budget for each year. Talked about reserve studies. We recommend having it done every 3 to 5 years, depending on your community, and may have it more or less frequent. Florida does not mandate a reserve study be done. I did some research on this. If you've attended this, you maybe heard this before, but I had to do some research on this for other states. And California in particular, the reserve analyst must have a great lobbyist out there, because there's a statutory requirement to have a reserve study done each year, except to say that a substantive one, I think, has to be done every 3 years. The other 2 years is more of a kind of a cursory overview to make sure, without going and looking at all the components, that everything looks to be on track. But that's a good way to keep reserve analysts in business, by having a mandatory reserve study done. All right, so that's what we have from the financial standpoint. Then we're going to go into official records. I've got a couple other statutory amendments, and then we're going to dive into as many questions as we can, while we're here. So thank you all for sticking with us on a Friday, although it looks like it might be raining out. So it's not like we're really keeping you all, hopefully, from enjoying yourselves outdoors. Might as well, if it's raining, might as well be listening to some attorneys talk for a couple hours this morning. Yeah. All right, so records maintenance. The official records of the association are open to inspection by any association member or authorized representative. That hasn't really been, defined too much, but what I define as an authorized representative is say, hey, I can't be there, but my son, here's my son's name, I want them to go and look at them for me, or my attorney, something like that. I typically advise the association to be pretty inclusive of this and not be too restrictive. You don't want to look like you're trying to hide something if somebody puts in writing that this is the person that can look at the records for them. The right to inspect includes the right to make copies. So they're allowed to bring in a portable scanning device. They can take pictures with their phone. They're not allowed to take the records with them, but they're allowed to make copies or, run them through a portable scanning device at the time that they inspect the records. The records shall be maintained within the state. I don't know that it really matters to us. Maybe for some of you, I know we have from Nassau County, depending on where maybe your official office is, maybe from a management company perspective, I'm pretty much all of our clients, and we work with our Florida community association managers, they need to be maintained within the state. Records shall be made available to owners within 10 working days of receiving a written request. So there's some arguments to what a written request is. If an owner emails the management company and says, I'd like access to the records, and it otherwise kind of checks the box, I typically treat that as a written request. There have been some cases where they say if the manager they can prove that the manager did receive the email, that's deemed to be when the start date is. So, you can pass some rules regarding this, and we'll talk about that in a little bit. Maybe state that it needs to be in writing, certified mail, but even if they email it, I just err on the side of caution of reaching back out to them. You don't want to be on the wrong side of, well, it was an email and yes, we did receive it, but because they didn't mail it to us in hard copy, we're not going to treat it as an official request. Most arbitrators and judges are going to side with the owner on something like that, and then we could be subject to statutory fines for it. The big thing too is that, and I have this last bullet point, which is that the association is not responsible for the use or misuse. Where that comes into play, say, look, we know why they're asking for these records, Ed, and I think they're going to try to embarrass a board member or embarrass a member in the community, and we don't want to provide them with access. I have to respond and say, hey, unfortunately, they're provided access, but we're not going to be held responsible by that person that might be embarrassed, that might try to come after us and say, why did you provide them with a copy of my ledger? Our response is we had to. We apologize, but we have to. And that's what the statute requires. The other thing too, though, that's part of this, and I had to litigate this before and went to an arbitrator, and Mike is familiar with this one, where a member asked for certain copies, where they said, I want copies of these documents within 10 working days. The arbitrator actually said that that's not a request to inspect. You're asking for copies, and you as a board or as an association are not required to go through and find those things that they're asking for. All you have to do is make them available for them to inspect. And so that owner sued the association and said that you're in violation because you didn't provide them to me within 10 working days. The arbitrator ruled with the association, my client, and said, no, you made a request for copies. That's not the same thing as a request to inspect. So they weren't liable for not providing them within 10 working days. They made efforts to, and they eventually had access, but it wasn't a violation of the statute. So just be mindful of that too. So here's some of the records maintenance. I know this is in small type. This is where I also tell you too that I know we have a lot of slides here that in addition to emailing you your certificate, we're going to email you a copy of this PowerPoint too, by the way. So if I'm going through this stuff, or especially if you see a lot of this on this page, I'm not going to go through all this. That we'll provide you with a copy of this later on. Condos are required to permanently maintain copies of the plans, permits, warranties, and other items provided by the developer. A copy of basically the governing documents. Your minutes now have to be maintained in perpetuity, and your accounting records. For HOAs, it's still 7 years. And then for condos and HOAs, you have to maintain for at least 7 years your roster and mailing addresses, your voting certifications, insurance policies, your management agreement, bills of sale. And then this is what Mike talked about before, all other written records related to operation of the association. So that can be anything under the sun potentially. There's some questions as to whether or not, emails with the board members individually or board members and management constitute written records. What arbitration decisions state right now is that if it's between board members and it's not on an association owned computer, that those might not be official records open for inspection, but that once you copy the manager in, that now, because the manager's job is to obviously administer the duties for, whatever their job is as the managing agent, that now it becomes an official record. So just be mindful again of what you're emailing it, whether or not it's open to inspection by a records inspection request. I could tell you that if there's ever a lawsuit, those emails are certainly going to be discoverable. And there's a difference between what's an official record open for inspection versus what's a document that needs to be produced in discovery. So just be careful about what you're emailing. I always recommend that even if you're going to use email for the purposes of, coordinating time for meetings or making sure that you have what you need or asking the manager to reach out on something, try to create your own email that's just for that association. Definitely don't use your business. This is just more for you, for you and your employer, is not using your business email. You don't want to have, a lawsuit come down and then they have to propound discovery on your employer to have access to your emails to try to find out what was association business or not. The other good thing about creating an email address is that once you're off the board, you can then turn it over to the next board member. And there's a little bit of institutional knowledge that they can go back and search through and find some emails. Even if you don't have them printed out, it's easier to find that way. So I'd recommend doing that if at all possible. For condos, there's certain things from a records maintenance standpoint, your ballots, sign-in sheets, and proxies, you have to maintain those for 1 year from the date of the election. I've gone through some elections recently, and I had to tell them, yes, you still have to keep these blue envelopes and all these things, even if they're all ripped up from you, opening them up and counting the ballots out, all that stuff has to be kept for 1 year from the date of the election. Any rental records as applicable, a copy of the current question and answer sheet, that's unique to condos. That you have to keep, that has to be updated yearly. A copy of the inspection report is provided by statute. And then as of July of 18, you have to keep your electronic records related to voting. I should have brought this up as part of the election discussion. I found a lot of communities that have looked to electronic voting, and that's helped for election purposes, especially with COVID, with people not wanting to get together. Take a look at electronic voting. We can help you. We've drafted the resolution that's needed from a board standpoint, and then help advise as to what the steps are. The biggest thing is that owners need to opt in for electronic voting. So they need to sign or electronically sign or authorize that they be included as part of the electronic voting and notification process. So it's not enough for just the board to set it up. You need to have owners opt in to do it. And you still have to have a bifurcated process. So all the people that opt in have electronic voting, but you still need to send out your paper ballots to all the people that didn't opt in, and then you combine the results from the two. But I found a lot of communities that I've worked with that they were never able to have an election because they didn't have enough participation, but by passing and going through the electronic voting process, it was able to help get a lot more people, where it's a lot easier just to click a couple things and then their vote is cast electronically rather than filling out their ballot. It's confusing, especially from the condo side, that you have to stick it in one ballot and not mark it. And then you have your proxy in addition to that. And then you've got your outer ballot or envelope that you have to sign and send back. It can be a confusing process, and it's a lot easier for some people to do electronically. So take a look at that too. But the electronic records related to voting are considered an official record that could be open for inspection. Very small type up here. All I'm going to say is that if you're a condo of 150 units or more, you do have a requirement now that's been in place for pretty much 2 years now, that you have a website that has all of these documents that have to be made available on the website. There's been some discussion about lowering it for 150, maybe even down to 100 or 50. We'll see what comes out in the legislative session. That may be, obviously more condos have to have websites. I like when condos have websites and you stay on top of keeping your documents here, because it really helps with the records inspection standpoint. If you can just say, hey, everything we have is on our website, here's your login for it, then you don't have to worry about coordinating the time for access. It's all available on the website, but you do have to maintain all of these documents on the website. I'm not going to go through all of them. The other thing that I would recommend, because there was kind of a little cottage industry for a couple of months that went away, where you had these LLCs, or they were, Citizens for Justice or something like that. And what there were these Delaware corporations or LLCs that were trying to sue associations of whether or not their website was ADA and FHA compliant. And they were saying that they were testers and that they were trying to strong arm the association, saying, oh, we of course want you to fix this, but we also need $5,000 for our time and expense on this because attorney's fees can be imposed. So, there were some threats for that. I never actually saw any lawsuits come forward. Not to say that that won't happen in the future, but I bring this up that if you do have a website, get with your management company just to see how it's set up. That I recommend kind of one landing page and making sure that that's FHA, and then maybe if you're subject to the ADA, that it's ADA compliant, but that you have the login and that all this information is behind the login page, so that even if there is an issue with how the website's set up from an FHA or ADA standpoint, the only people that can complain are your members and not people from the public. That's a big distinction. So not to go off on that tangent, but just, take a look at if your website and if it's compliant, and how you have, the landing page and the login versus what's behind that kind of login requirement, so that, now it's not open for the public and it's only your members that have login access. So what records aren't accessible? Any record protected by the attorney-client privilege or work product privilege, any information obtained in connection with the sale or other transfer of a unit, any personnel records, medical records. This comes up where, we talked about emotional support animals. If you have an emotional support animal request, and maybe, they submit information from a doctor or medical provider as to why they need an emotional support animal or some type of an accommodation under the FHA or ADA, that would be a medical record that needs to be kept separate, and it's not open for inspection by the membership. Any electronic security passwords that the association may have for, its accounting software or website or anything else, a clever owner may try to say, I want that because it's an official record. No, they don't get access to that. Same thing with software and operating system access information. Other protected information, if you happen to have social security numbers, driver's license numbers, credit card numbers, all this stuff, identifying contact information is not open for inspection by the membership. Owners can consent. They are able to consent in writing to allow the disclosure of their personal protected information. The biggest thing is emails. Just because you have an owner's email doesn't mean it's open for inspection. They actually have to provide consent to make that open, and for also using that for the purposes of providing notice in lieu of mailing it. That's one thing that comes up a lot, that you need to have owners actually sign off and say, I authorize you to use my email to contact me for official notices. If you don't have that, you still have to mail it to them as required by the statute. Statute was clarified for condos and for HOAs that all telephone numbers may be included in a directory, although an owner may choose to opt out. And again, they can opt in if they want to have their email address included. So we talked about inspection. They have to be made available within 10 business days. It used to be 5 business days at least for condos. So now it's 10 business days for all of them. Usually what happens is you submit the request to inspect. We take a look at it. Is it a valid request? Yes. Okay. Then usually the management will reach out and say, hey, you can come in on this date between these hours. We'll make the records available for you. You're not required to go through and find the records that they're asking for. But if they do say, hey, I just want to have access to these documents, if it helps to limit the time, you're allowed to do that and say, hey, you asked for these. We made these available. You can take a look at them. But if it's a really, if it's a 1-page long request with 20 bullet points, all you have to do is just put the boxes out on the table and say you're able to look through them. Everything you're asking for is in here. Feel free to take a look at it. You can comply with the inspection requirement by either having them available, like I just talked about, for inspection or copying on the property, or by making them available electronically, whether on a website or if you've got them on a computer. I know some associations through management do that, where they might say, here's a computer, here's the access, you can look through them. Association's not responsible for the use or misuse of the information provided. We talked about that before too. The big thing, and I want to mention it, I don't have it specifically on here, is that if you don't provide them within 10 business days, there's a rebuttable presumption that you're in violation of the statute, that you willfully failed to make them available. And then you can be fined $50 a day up to $500 unless they can prove that they were damaged in a different monetary amount. And the main way I can see that coming into play, that being more than $500, if they can say, hey, this was in connection with the sale. My potential buyer wanted to have access to these, and so I needed to inspect those. You didn't make those available and the sale fell through, and I had to sell it to somebody for $5,000 less. Therefore, I was damaged $5,000 by your failure to make them available to me within a certain period of time. I could see that maybe being an argument. It has never been brought up before, but that's where I could see it falling within that statute of $500 or another monetary amount if they can prove it. So that's why it's important just to really make sure that you abide by this and make them available. All right, so that's what we have for the records inspection. Just for some more recent legal updates, emotional support animals. There's a new statute. It was actually added as part of the Florida Fair Housing Act. It basically kind of mirrors that, but it adds some components in. It says that it's unlawful to discriminate in the provision of housing to a person with a disability or disability-related need for, or who has any time obtains an emotional support animal. And then they define an emotional support animal as an animal that does not require training to do work, perform tasks, provide assistance, or provide therapeutic emotional support by virtue of its presence, which alleviates one or more identified symptoms or effects of a person's disability. So emotional support animal is different from like a service animal in that it doesn't have to have training, as long as it's prescribed essentially by a treating healthcare provider that it's necessary to alleviate a disability that affects a major life activity. That's an emotional support animal. Documentation may not be prepared by a healthcare practitioner whose exclusive service is prepared documentation in exchange for a fee. So there are some services that you can Google them where it's like $99.99. You get an emotional support animal document from us, and they'll have a 5-minute Zoom call with you or something like that. They are cracking down on that, where it's the cottage industry of providing this. There is a requirement that if the healthcare practitioner is out of state, that they must have provided in-person care or services on at least one occasion. The landlord, but I put in association as a question mark, may also require proof of compliance with state and local licensing and vaccination requirements. And there are criminal penalties if you provide a false or fraudulent proof for the need of an emotional support animal, which is a second-degree misdemeanor. So there are some, they're recognizing that some people are abusing this and that they want to have a way to verify that it's not from some person whose job it is just to provide these letters, that it's some type of a treating healthcare provider that, hey, as part of this, I have prescribed this animal. We can spend more time on that upon request, but just know that if you do receive an emotional support animal request, there are ways that you can look at certain information. It's not enough to say, hey, here's my certificate that this is a trained emotional support animal. That's a telltale sign that they did some Googling and thought that they are going to pull a fast one on you. Get with your legal counsel to make sure that you're handling it properly. So again, communities with pet restrictions are strongly encouraged to adopt procedures for requesting accommodation in the form of an emotional support animal. I always think it's better to have procedures in advance so that you're not reacting when you receive a request in the moment. And the big thing to remember too is that a pet and a support animal are not the same thing. I had some communities that represented said, well, Ed, we don't have to accept this request because we don't allow pets. Well, no, an emotional support animal is not a pet if it's a valid one. Think of it as if they were saying, hey, I need to have a ramp because I'm in a wheelchair and I need to get into my unit. You would say, well, yes, you need that to enjoy your unit in order to have access. It's the same thing with a pet if they go through, with an emotional support animal, if they go through the appropriate procedures to say, I need this to enjoy my property in the same way that somebody that doesn't have the disability. So that's why it's important to treat these and take these seriously, but also have some procedures in place and that you can ask some questions regarding it. A couple other things. There was a bill that passed last year about law enforcement vehicles and includes provisions which preclude an HOA or a condo from prohibiting a law enforcement officer from parking their law enforcement vehicle in certain areas. So again, if you've got somebody in your community that's a law enforcement, whether it's a police officer or sheriff or something like that, or state deputy, and they're parking on the street, just don't give them a hard time if they live there. Better to have them on your side. You never know that you might want to have them, hey, can you just drive around every couple of times? We've had some people, causing problems at this park. No problem. I'll drive through before my shift ends or something like that. There is some now, I've never seen that where I've been asked to send a letter to somebody that lives in the community that's in law enforcement that's, tried to tell them to not park on the street. Just, you want those people on your side. Fireworks, you're allowed fireworks on designated holidays, but if you have restrictions outside of the New Year's Day, Independence Day, or New Year's Eve, you can still abide by and whatever the covenants provide, but there may be looser restrictions now as to allowing fireworks on those 3 holidays based on a bill that passed last year. Really, this is probably the smallest font that I have on here. So hopefully when you receive this, if you can't see it on the screen, when we email you the document, really it was just for condos that there was a changes to the material alteration statute that said that if you do have to have a member vote, it needs to be done before the alteration takes place, not afterwards when somebody challenges you. And for electric vehicles, for charging stations, if you found that for condos, installing those would be a material alteration and normally would require a member vote. They wanted to have that so you didn't have to have the member vote, but that the owner would have to basically protect the association by making sure that you abide by all applicable building code and safety standards, that you have some type of an engineer look over it and improve the plans, that they comply with architectural standards, that you have a certificate of insurance naming the association as a digital insured, and that you pay for any increase on the association premium, and that you pay for any additional electrical charges, basically everything to say that we'll let you do it, but you got to follow all these guidelines and we don't want to have to pay anymore because you're installing it. You have to foot the bill for it. So they do that to allow electric vehicle charging stations without otherwise requiring a member vote for it. The other thing too is that the cost of installation and removal is the responsibility of the owner, and that if the association has to do it, they can charge it back as an assessment under 718-116, which is the assessment portion of the collection portion of the Condominium Act. A couple of HOA updates. If you're changing your governing documents for HOAs, you do have to record those. And if you're adding anything or striking out, you have to underline for any additions and strike through for any taking out. We've already done that whenever we draft those amendments anyways, but now it's a requirement in the HOA Act like it has been for the Condo Act. The second bullet point is kind of a big one that I think I've been trying to remind whenever I teach this class, is that any notice that has to go out under 72306, which really is regarding a member meeting, so like your annual meeting or a special member meeting, the association has a duty to check the property appraiser's website to see if there's a different address than what you have on file. And if there is a different address, they have to mail it to that address in addition to the official one that's on record. Previously, it's the owner's obligation to update their mailing address, and you just had to rely on what the owner provided you. Now there's a duty, and I can just imagine, I know some of you in here are in a master association with maybe 1,500 members. That's a big process, and it's a big duty and obligation to place on the association and management. Talk with your management company to make sure that if they're doing that as part of their mailouts, that they are in fact checking the property appraiser website. Because what could happen is if somebody really wanted to challenge, let's say a declaration amendment, for example, they can say, hey, I never received notice at this address, which is on the property appraiser website, but you never mailed it there. And so therefore the notice was invalid and the whole vote is invalid. That's a potential ramification for it. Or an election, challenging an election result. So be mindful of that. That's been in place for about 2 years now. The other thing that was put in place was that they kind of closed a loophole for payment of assessments. If somebody tried to game the system by saying, yeah, I know I owed $1,000, but I'm going to try to send this check for $200 that says payment in full. there was a previous case where if you accepted that and you had been discussing their payments with them before, that might be deemed to be what's called an accord and satisfaction, that you're resolving a disputed debt. Now the statute says that regardless of whatever you put on your form of payment, that the association still applies it as a partial payment. And so if they send in a $200 check for a $1,000 delinquency, you can still go after that $800 difference regardless of them trying to slide something under the door that way. The last thing that we really have substantively is for the Marketable Record Title Act. It's MARTA. It only really affects HOAs, and it's because of the difference between condos and HOAs in the form of how there's a transfer of title every time that a property sells. If you ever take a look at your deed, take a look at your deed if you're an HOA and look at it, it probably says lot 100 of such and such community, and it references the plat, book, and page number, but it doesn't reference the book and page number where your covenants are recorded. As opposed to if you're in a condo, take a look at your deed for your condo, which says unit 100 of the whatever condominium, and the condominium declaration is recorded in the book and page number. Because every time you transfer your condo, it references the book and page number for your covenants. It's not subject to what's called the Marketable Record Title Act. Whereas for HOAs, if you don't preserve your covenants within 30 years of when they first became effective as to the parcel, those can expire. So you have to make sure as a board that you preserve those. If you don't, then your covenants expire, and it requires membership approval, and it's a lot more expensive because you have to go to the state and get approval for it. And so there was a change. That Marketable Record Title Act has been around for a while, and how it affects HOAs. There has been a change in that it simplified the process for preserving it, and it makes it inclusive for not only residential homeowners associations, but non-residential property owners associations. We might have a couple of you in here. Maybe you're in a commercial property owners association, and you have covenants and restrictions. Previously, it only said for residential HOAs as defined under 720. Now you may have the ability to preserve your covenants, so take a look at that. We just wanted to make sure that you're aware of that. And also just generally, if you're in an old HOA, maybe your HOA is 25 or more years old, and you want to go and look at it from when your covenants were first recorded, that's the safest thing to do, and say, hey, we're getting pretty close. We should just have our board vote to preserve this. Contact your attorney. We can help you to let you know what you might need to do it. It's pretty simple. It doesn't require a member approval. So just be mindful of that. You don't want to have your documents expire.
One quick thing to add is a lot of association boards go, well, we did an amendment 5 years ago, so the 30 years restarts then. That's incorrect. It's from 30 years to the original recording. Additionally, your documents will indicate, they'll say, these are hereby good for 20 years and automatically renew for 10 successive years every year. That doesn't matter either. That it has to be done every 30 years. This is an entirely different statute that basically the title industry created, so they don't have to research covenants all the way back to the root of title. So what I'm getting at is no matter what, no matter what, they expire. So if you're within 5 years of that 30-year mark, you probably should have an attorney take a look at it.
Yep. There was a change that maybe you could consider an amendment after the statutory change from a couple of years ago. But even then, you have to make sure you do it right. So you can't just say, well, we restated our documents or we amended them 10 years ago before the statute changed. Talk with your legal counsel. You'd rather just be safer than sorry and have the board meeting, preserve the covenants, and record the necessary document, the resolution, rather than having your covenants expire, because then you lose the ability to enforce your restrictions, require people pay assessments. It's a big deal, obviously, if your covenants go away. So take a look at that. All right, so in summary, the board members have a fiduciary obligation to set aside their personal agenda and put the association first. You want to stay focused on the job at hand, be familiar with your governing documents. You don't have to memorize them, but just be familiar with them, of course. Rely upon the appropriate people to help you make decisions. Know your duties and perform them competently. Set goals and establish values. Mike talked about that kind of earlier on. It started some of the practical things of being on the board and what your goals are, and not being too crazy with setting them so that you can't get everything done and you don't focus enough on one item. But set your goals and what you want to accomplish. And I always like to include this: obtain the necessary education. All of you really, take your right hand, put it over your left shoulder, and pat yourself on the back for sitting here for, where are we at, 2.5 hours with another. We've got a lot of questions here that you sat through, and to obtain the necessary education. I hope you got a lot out of this from us, that, to learn more about your community. I'm going to keep the next slide up because it has our contact information. Go to our website. If you maybe didn't receive this and if it was forwarded to you by somebody else, if you go to flcalegal.com, you can scroll down, you can find a way to subscribe so that you receive notifications of classes that we teach in the future. Also, we do email blasts, like if there's a legislative update that you need to be aware of or any kind of hot topic issue that we do a blast on or a blog post. We promise not to spam you. We try not to email you too much, but that way you can know about our future education opportunities through our firm and everything too.
And also on the website, if you're a client, there is a client portal where you can get all of your matters and every single status associated with all your matters in real time. That interfaces with our software here in the office, so you can see every single letter, every single certified letter, whether it was signed for. From a collection standpoint, you'll be able to see everything in one location.
Yeah. All right, so I'm going to dive into it. We have 135 questions. We're not going to be able to get to all of them, and so we'll do our best. But if you work with us, we're of course happy to reach out and maybe better advise if it's a specific question for your community. But let me go through here and we'll start this out here. All right. Oh, I see a Go Packers. Thank you from the beginning here.
The handouts will be available. We'll email them out to you along with your certificate.
Yep. There's one question that said, if some of us took this course before, will be 5 years in April. Do the certificates expire after 5 years? As long as you stay on the board, there's no expiration there. But if you did get off the board previously after you took it and now you're back on, then this will apply for as long as you stay on the board. Somebody asked, I'm from Kansas City, will you boot me off? Well, no, you made it all the way through, bud. And so I hope you obtain a lot. And best of luck if my Packers meet your Kansas City Chiefs in the Super Bowl. So David asked, would you explain what is legal as far as using email between board members? What can we talk about? And Mike, I'll handle this one first real quick. It's impractical to say that you can't use email. What I would say is use it for organizational and planning purposes, coordinating meetings. The example that I like to give is say, hey, at our last meeting, we asked our manager to go get 3 bids for whatever vendor you have. And then the manager in advance of the meeting says, hey, here are the 3 bids that I received. Please take a look at them to make sure that nothing's missing or that you'd like to have added before the next meeting. I think it's okay for the board to email back and forth and say, hey, I like this, but this company didn't address this issue. Can you go back to them and make sure that they add to it so we can address it at the meeting? I think that's appropriate communication, where I think that if you use your email to say, hey, I really like this company because of this, I don't like this one, what do you all think? And everybody goes back and forth so that by the time they get to the meeting, they've kind of addressed who they're going to hire already. That's where a lot of members, again, get upset that feel like everything's being done outside of a meeting. The other thing that I was going to mention, Mike, when you were talking about it is so many boards say, hey, it's impractical to say, that we can't vote by email. And I like to turn that around and say, is that really a board decision that you're voting on? Or is that something that really you should trust your manager or your president to be able to make a decision that doesn't really require a board vote? That's why you have your president as your day-to-day officer. That's why you've hired your manager. And so I'll turn around and say, you really shouldn't be voting on this at an open meeting in the first place. It's something that your president or your manager, you should trust them to be able to do this. So Mike, what do you think about that?
No, I agree.
Yeah. Let's see, you talk about the handouts here. Gerard asked, does a landscape committee need to follow the rules for posting the meetings and recording minutes? So one thing to mention about committees, every committee in a condo context have to be noticed in the same way as a board meeting in terms of 48 hours notice and the appropriate steps for that. For HOAs by statute, the only 2 committees by statute that you have to notice meetings are an architectural committee or any committee that has the ability to use association funds. So if you have a budget and they can say, hey, we're going to spend this much, even on a social committee that maybe says we're going to have a party and we've got a budget from the board and we're going to make a decision at that meeting. And it still is document specific. So if your documents require, like in an HOA, all of your committees. So that's the only thing from a statutory standpoint, from a governing document standpoint, you may have a catch-all that just says all committee meetings need to be noticed like a board meeting. Maryland says, doesn't government in the sunshine apply if there's an architectural review that requires a county permit or variance, a public hearing to be held? Again, it may be different in terms of what they may need to go through from a county standpoint, right?
Right.
Versus what the HOA has to do. But I kind of just addressed that from an HOA perspective, that meeting where the HOA is going to approve what it's allowed to approve has to be done in an open meeting.
And it's not subject to government in the sunshine.
Yeah. Let's see. Chuck wants to know, does the declaration also apply to a CDD? A CDD is a community development district. It's kind of a quasi-governmental HOA. It's different. That's its own separate entity from the HOA itself. There may be some overlap in terms of if the CDD owns property and what it's required to maintain versus what the HOA is required. So there is some, a relationship there to make sure that each party is doing what it's supposed to, but it's a different entity from the HOA.
It seems like a glitch.
What's that?
The next question.
Oh,
I'm sorry.
It says, if our documents require an odd number of board members, but only 6 people run for the board, if the answer to take only the top 5 vote getters or all 6, okay, so the question is, if you're required to have board members, I think the question is, well, what if we have a 7-member board, but only 6 people run, and we have to have an odd number of directors? Can we just say, well, we're only going to vote for the top 5 then to keep it as an odd number? That to me would depend on what your documents require about how to change the number of directors. I'd be careful about not having an amendment or some type of a board vote to say how you're going to handle that, because it may look like, well, we don't like maybe one of these candidates, so instead of making sure that person gets on, we're going to reduce the number of directors. So I'd want to have a process in place, and more importantly, probably as part of the bylaws, so that it's not in reaction to who's running so much as, hey, if you only have, you can always have an odd number, and if you don't have enough to run to have an election based on your previous year, it goes down to the next number of odd that requires an election. I don't know, something like that. It would require talk with your legal counsel and getting an appropriate amendment done. And then would the board be required to ditch the even number? Again, that just depends on what your documents provide there. Maybe in that context, if you had to keep it at 7, you had 6 run, you have no election, but then the board would have the ability to appoint a 7th member, maybe go twist somebody's arm to say, hey, would you run? Because we need to have a 7th member and we can appoint you as a director there. I think there was a question about supermajority, not just those voting. I think the question, it just depends. You have to look at what the statute of the documents we require. The key language is a majority of all members. That to me means so if you have 100 members, and if it says a majority of all members must approve, period, that means 51 of the 100. If it says a majority of all members at a meeting where a quorum is met, you have to make your quorum and see how many of those people are there in person or by proxy, and then a majority of those members. So it's important to see how the document or what the statutory provision is. Somebody says we want to run our own meetings without the management company. Wondering what do you need to know? Must we take notes? What has to happen with the notes? So, the main thing is you post it appropriately, give appropriate notice for it. Then you have somebody take notes, and then a secretary that drafts the minutes. And there's no requirement that management be there. They typically perform most of those functions. So, but if you do have any notes or records, of course, from that where the management's not present, that would still be deemed to be an official record that's open for inspection. I think, James, I answered your question before about having exceeding a budgeted line item or if a homeowner vote is required. I think it's just an estimate. So we handled that before. What I might do is I might just scroll down because I know we have a lot of questions from I might just try to find some. And I apologize, everyone, if we can't get to all of your questions. We had a lot of great ones, but we want to make sure to kind of keep us within the time period, and then reach out to us if we can help your community, of course. Maureen says, who checks that board members have certification? If a board member remains on the board for more than 5 years after taking a certification course, do they have to retake? I think we answered that before, but somebody could, some homeowner could say, I did a records inspection request and so and such never signed this document and never took this course. So they're deemed to have vacated their spot on the board. That's effectively what would happen. You're technically deemed to have vacated your seat on the board if you don't take this course within 90 days after becoming a board member, or if you don't sign something. but as soon as you take it, you're back on. So it's not like you're off for good. It's just that it's a temporary thing until you correct the issue. Mike, do you want to address it? I mean, there's a question here about indemnity and whether or not you can be personally sued.
Yeah, so you can, the indemnity doesn't prevent you from being sued. And the key piece is that you have to act in good faith to actually trigger coverage by the association's D&O policy. So you can always be sued personally by being on the board. And you can, there are instances where the D&O doesn't pick up coverage. I've never seen that, but it could happen if you're acting in bad faith.
I think one question was carport coverage. Should that be insured? Yes. Any structure that you have, yes.
And be careful about carports. So the way the policies, those insurance policies are written, it actually specifically says that aluminum structures are not covered. So if you have a screen enclosure on your pool or carports, you need to make sure you have a rider associated with those structures, including docks. We have docks too.
One quick question, is there any case law on secondhand smoking that affects neighbors on the same building or common wall? There is some case law from different states that talk about whether or not that's considered to be a nuisance, and then whether or not the association had the obligation to prevent that. So if you're thinking about it, we've looked at this for some communities, especially, adopting rules regarding common area use. It becomes more of a personal issue when you're talking about restricting smoking or whatever within a unit from unit to unit and potential damage there. So that's something that really should be looked at by legal counsel to help advise you as to what steps you might need to take to make sure that something like that would be enforceable.
That's a good one.
John asked a question about construction defects. Does this apply to new construction only or also include major renovations? So yes, it applies not only to new construction, but major reconstruction projects, whether it's a new roof, especially for the oceanfront condominiums with the restoration projects, balcony replacements, that kind of thing. Anything like that, that could be subject to a construction defect lawsuit that has the appropriate time limits that Mike mentioned in terms of 4-year statute of limitations from when you knew of a problem. But if it's a latent defect that maybe you didn't know about, you still have 10 years from really completion of the contract to bring a claim so that, somebody can't be sued 20 years after the fact. There are some time periods. So if you suspect that something may be a problem, especially depending on the time period, you're always recommended to get an engineer or somebody out there that can look at it to evaluate if you've got a potential claim. David asked, can board members talk on the phone to each other? What can be discussed? Again, if you have a quorum and they're all talking on the phone, and if you're talking about association business, it's likely to be deemed to be a meeting, and that should have been noticed to the membership. Michael asked about construction defects for condo type dwellings. It'd be for condos. It could be for townhomes. It could be for single family homeowners. You have the ability to bring claims. It is more difficult to bring it as an association on behalf of single family homeowners. It has to be more of something like where the association has a maintenance obligation, maybe on the roofs or the exterior. But certainly like, the pool or the common area, the clubhouse that the association owns, even in the HOA context, that could be the basis of a construction defect claim too. James wants to know, are special assessments a board vote or homeowner vote? Depends on your governing documents. It's very document specific. Marilyn wants to know briefly about selective enforcement. I think it's good for everybody here. Selective enforcement means that it's an affirmative defense. An affirmative defense is an owner saying, yeah, but. Like we might say, you're in violation. You put the shut up without getting owner approval. The owner may say, yeah, but other people have done the same thing and you haven't gone after them for it. So selective enforcement is an owner saying, you're picking on me and you're not going after all these other people. And it's one of the most common defenses on a covenant enforcement dispute. Let's see, I'm going to kind of skip ahead again, everybody. I apologize. We have a lot of great questions. I'm trying to get as many as we can. Arthur wants to know, is it legal to prohibit renting of homes in a homeowners association covenant? There's nothing prohibiting that so far in terms of like from a statutory standpoint. You'd have to get the appropriate membership approval. And there's a big difference between the condo and the HOA. Condo, if you try to implement that, it would only be applicable to those who vote in favor of such an amendment and then any future owners, because they're deemed to be buying the property subject to that amendment. For HOAs, there's nothing yet, although there is some talk about trying to kind of mirror the Condo Act in terms of even if you reach the appropriate threshold to amend your documents, it may only still affect those who vote in favor and then any future owners. Let's see. I guess real quick, what's your advice on dealing with renters on issues that they have with the condo development rather than only working directly with the owners? I think you can work with both. Again, it just depends on what the nature of the issue is. If it's a renter, though, that's in violation, at some point you might be sending them notices. Then we want to get the owner involved to say, hey, your tenant has a problem here. And you want the owner to maybe take action because they have the ability more easily to evict the tenant than the association does. So that's where you especially bring the owner in. And a lot of times what we say is, hey, find the owner. They're responsible for the activity of their tenant. And that might get their attention to actually do something to get their tenant, to follow the rules. All right, let's see. Jane wants to know, is there a general rule or guideline regarding political signs on communal property or in the windows of individual units? This came up in the last election. There's no statute. You would have to have something like that in your rules and regulations or your governing documents. Mike, you've had to deal with a sign or American flag issue before.
Yeah.
What would you say regarding that just for political signs?
Typically, we pass rules and regulations that allow it for 2 weeks and then require people to take them down after that.
Right after the election, right? Yeah. I saw some creative arguments this election from people that felt very strongly that there was some First Amendment right to have a presidential flag from their house, and that does not apply, for private HOAs with covenants and restrictions. Michael wants to know, HOA financials, do the checks require 2 signatures? That's not any type of a statutory requirement at all. Robert had a good question. I think it goes back to what I call the barbecue rule. Is the interaction contributing to the development of ideas that constitutes a meeting applicable only to situations where a quorum of the board is present? So yes, one way to get around it is if you have 2 out of 5 board members talking, that's not a quorum of the board. Therefore, it doesn't need to be noticed as a board meeting. All right, I'm going to skip down here a little more.
Yeah. You're look on the right. You're only a quarter away.
I know. Let's see. I'm going to try to get down maybe a couple more here. So folks, we're going to take maybe about 4 more questions, if that's okay. Reach out to us if we can assist your community, of course, and answer more specifically for a community. Let's see. We answer about smoking in common areas. All right, Francis has a great question. The Florida statute states that a physical place for holding the meeting must be stated in the meeting notice. With Zoom meetings, is that still required? Can the meetings be held totally remotely via Zoom? It's a great question. I think it's going to be addressed in the next legislative session in reaction to, there's the emergency powers that we've been able to use as part of COVID in the state of emergency. But it talks more about postponing and canceling meetings or having meetings with less notice than what, if you need to have, less than 48 hours, but it doesn't talk about the method of having the meeting. We've been typically advising clients that we think that Zoom meetings or whatever telephone only meetings for board meetings is okay. And I think the reason that I've given is because only board members are able to vote at those meetings, and they have been able to participate at those type of meetings in the past and be deemed present, whether or not they were there physically at the property. And so that's why I felt that Zoom meetings were more appropriate. Also, you just have the idea of, look, we'd rather have a meeting via Zoom or telephone than not have a meeting at all if we have to meet in person because we don't think it's safe to do so. I think any judge would probably defer to the association on that because you'd rather have business conducted where membership can attend rather than putting people's safety at risk potentially by having an in-person meeting where you can't safely social distance, something like that. For membership meetings, though, we've still recommended having some type of a physical location and asking people to use that just for dropping off a proxy or a ballot and then going back home and then participating via Zoom. And the reason why I still said there should be a physical location because there's no way for a member to vote completely virtually via Zoom like you can in a board meeting for a board member. And so you want to have the ability where they can go the day of and drop something off and have a physical location for it. That's kind of the justification I've given. I'm not saying that it's been tested yet, but that's kind of what we've been doing. But we can foresee changes to the statute that if there is a state of emergency, that maybe having some type of a method for having it completely virtual and having a process for that where members can be present virtually and cast a vote, for example, something like that. Chuck wants to know, can the finding committee meeting be held online? Similar to that, I think that as long as you have a way to potentially have a method for everybody to freely participate. My only concern with that is that if somebody wants, because there are cases that say that the member has the ability to present evidence, and if they feel like, well, I don't have a good way to hand you this via Zoom, that they may object that they didn't have a full opportunity to hand you documents and show you something. So I'd be more hesitant from a finding standpoint because of the kind of the interactive process that might be. I'd still try to have that at an in-person meeting. I don't know, Mike, what do you think about that from a finding committee?
I mean, it's final decision-making authority. I would, yeah, I agree with that.
Try to find a place if as best you can, even if it's outside where you can socially distance. To you don't want to have then somebody say, well, I was prevented from stating my case and they upheld the fine. It was because it was held via Zoom and the connection was going in and out. Like I could see people raising that as an issue and finding a way to have the fine invalidated. And
it's especially, you have to be especially careful because you can potentially file a lien on the property if you're in an HOA, and that they call it perfecting a lien for a reason. That means you have to do everything perfect. So I would try to stick to the four corners of the statute and make sure you're actually having a physical meeting.
Yeah. Let's see, I'm going to take just a couple more questions. I'm going to try to scroll down here and see if I can find one from a different topic area. And again, I thank everyone for participating here. Robert asked a good question. Can delinquency period for board eligibility be reduced to a period less than in the statute, i.e. 30 days? I would say that you still have to follow the statutory requirement. I suppose, I mean, I haven't tested that before. I could see, because you're trying to be more inclusive of allowing board members and allowing them to stay on the board, and maybe the legislature and maybe the arbitrators may lean more towards not kicking people out if the board wants to be more lenient for it. I would still err on the side of staying on the what the statutory requirements are. Mike, what do you?
No, I agree. I think the statute.
Yeah, I don't know that you can get around what the statute requires there. To answer this one real quick, proxy voting is only allowed if there are less than 10 members. I said that for the purposes of a condo election. If you have less than 10, you can have bylaw procedures that allow you to vote by proxy. Otherwise, for condos, you cannot use proxies at all for the purposes of the election. All right, what do you think?
Yeah, probably.
Yeah. So
53.
Everyone, thank you so much for attending. I know we have a lot of unanswered questions. You have our contact information. If we can help out with your community, please feel free to reach out to us. We'd love the opportunity to work with you. And for all of our clients, of course, thank you for attending today and for reaching out. We'll be having more education courses as we go on, especially this is going to be a more active legislative session where I think we're going to see some substantive bills passed for our community associations. So we'll make sure to advise you of that and have a class to kind of go over everything. But please make sure to go to our website, sign up if you're not already receiving emails from us in terms of like for this one, for example. And then also check out, we have a YouTube page. If you go on the top right there, you can see some of our past courses, and we'll be able to make this video presentation available too.
Have a good day.
Thanks, everyone.